Good morning, everyone. Welcome to the first day of our Harrisburg session. As many of you know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May, we celebrated our 300th anniversary with a special session in Old City Hall in Philadelphia. We're very proud of our rich history. Over the past 23 years, I've had the privilege of sitting on this bench here in Harrisburg in this majestic courtroom with these beautiful murals by Violet Oakley, a woman of incredible talent and vision. What a treasure this confluence of history and art provides to the people of our Commonwealth. The Capitol Murals Project was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. Ultimately, she devoted 25 years of her life from 1902 to 1927 to painting 43 murals in our capital. Violet Oakley went on to become one of the most respected artists in America. I trust that no one who works here or comes into this courtroom takes this gift for granted. While there are many things our three branches of government may disagree on from time to time, I know that our judiciary, along with our legislature and executive branch, all agree that we've been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals in our magnificent capital. Before the court crier calls our first case, I'd like to briefly remind counsel of a few matters of protocol. Please approach the podium when your case is called. I will then give a brief summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with the cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel may rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should not repeat the same arguments as prior counsel. Previous chiefs have referred to this as the no piling on rule. Please do not interrupt the justices when we ask you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues which we want to explore further. Our court does not permit rebuttal argument. Finally, while we have set no time limit for argument, I will advise counsel when we've heard enough, and at that time, I ask that you conclude your argument. Mr. Minner, would you call the first case?
Robert and Kelly Franks versus State Farm Mutual Automobile Insurance Company. Representing the Franks, Mr. James Hockenberry. Representing State Farm, Ms. Sandra Emmerich.
Good morning. In this appeal by allowance, we consider whether, under Section 1738C of the Motor Vehicle Financial Responsibility Law, an insurance company must obtain a new stacking waiver of underinsured motorist coverage when an insured who previously executed a stacking waiver form removes a vehicle from an existing multi-vehicle insurance policy. If I've got that roughly correct, would you proceed?
Thank you, Chief Justice Todd, other justices. My name is James Hockenberry. It's a pleasure to be here for the first time before the Supreme Court. I represent the appellants, Robert and Kelly Franks, the plaintiffs below. This is a case of first impression. The Pennsylvania Motor Vehicle Financial Responsibility Law mandates that when an insured purchases uninsured or underinsured coverage, UM or UIM for short, that it is stacked, that is multiplied across the number of vehicles on that insured's policy. One exception to that mandate in the statute is that insureds may waive stacking. They may waive stacking at the time of purchasing the UM and UIM coverage. The issue at its heart before this court is, what does it mean to purchase something? The issue of when an insured purchases UM or UIM coverage first came before this court in the Sackett case. In that case, the question was whether adding a third vehicle, a third car, to a policy with two is a purchase, or if the waiver that was initiated, that was signed at the beginning of the policy purchase was sufficient. This court held that adding a car to a policy is in fact a purchase. And it held that because when you add a car, it changes the sum of the coverages available. You can't purchase something if there's no opportunity to do so.
Counsel,
Yes, sir.
under our opinion in Barnard, what, in your case, what are you acquiring? We ruled that purchase is to acquire something that you did not possess, and one pays for that acquisition. Share with us, what is your acquisition?
The ability to stack coverage on two motor vehicles. Justice Doherty.
You already have that. You're removing a third policy. So you're asking us for mental gymnastics to interpret our decision of 3 years ago of acquiring, saying if you have two and you purchase a third, then you must get the waiver. You're saying now if you have three, and we were already paid for two, but I removed one, you want us now to deem that a purchase. And share with us why we should, in light of our 3-year-ago precedent, that there must be an acquisition, not a removal.
Justice Doherty, the reason is because the acquisition of something that one did not have before is the ability to purchase stacking on two motor vehicles. The statute is binary, as I point out in my brief. So when the Franks had 3 vehicles on their policy, they did not have the ability to buy stacking on 2 vehicles. There's either stacking or there's no stacking. Again, it's binary. So the flaw with in the reasoning with the appellee's argument, and I believe respectfully with the en banc panel's majority opinion, is that they held that when you remove a car from the policy, there's nothing there that you didn't have before. That is, I believe, the flaw in reasoning, because what you have now is the ability for the first time to purchase stacking on 2 cars, which you didn't before.
That's a creative argument, but I think it's a stretch, and to me it seems like you're really straining the language to get to that result. So if you want to amplify that, I'd appreciate it.
Chief Justice Todd, thank you for the question. I think it's consistent with the precedent of this court. For example, back in Sackett, the whole reasoning was because there is a change in the amount of coverage. The dissent in Sackett by Justices Castile and Aiken said, listen, no, it's an initial purchase. That's when you can reject it. It's only at the initial purchase. Simply adding a car doesn't do it. And that reasoning was rejected by the majority of this court. So it's consistent with Sackett and with Barnard.
It's consistent, except that acquisition is adding and removing is not adding.
It's Chief Justice Todd, I'm not sure adding would be the best word, because you are, in one sense, one is adding the ability to purchase something one couldn't before, which is stacking on the 2 cars. And so this issue of first impression, we have you have the 2 scenarios where the addition of a policy, with the addition of a car, at least without getting into the nuance of after acquired vehicle clauses, but for the purposes of argument today, that's a complication we don't have. So we have the scenario of adding a car to a policy is a purchase under Section 1738. Replacing a car under a policy, it doesn't change anything. There's nothing new. There's no new opportunity to purchase something that you couldn't have before. That's the second scenario. The case we're here about today in the Franks is the missing the missing holding from this court, which is when you delete a car. And again, using the same reasoning as in the Ship and Pergolese cases where it's replacement, Sackett and Barnard, here there is something new to purchase.
Counsel, but you don't only need a purchase, you also need payment for it. Where is it? I mean, the fact of the matter here, there was a decrease in premium. I mean, where's the payment? Where's the consideration, so to speak, for this opportunity that you're asking for? What's the payment?
Well, the payment didn't come to fruition, just like it wouldn't have in Barnard, because, or any of the cases in which the waiver is held to be invalid or there was no valid waiver.
But where would the payment be? I mean, period. I mean, forget about what actually happened. Under what scenario would there be a payment for one less vehicle on the policy?
The payment, Justice Donahue, would be for the stacking on 2 vehicles.
They're already paying for that.
Correct.
They're already paying for that. We have an X amount is being paid for 3. We're removing 1. The premium becomes less, which means we're still paying for the 2. So nothing has changed. Share with us how you've purchased something for payment pursuant to our definition in Barnard, that it now, purchase now equals removal with the acquisition of nothing and the continued payment for that which I've been possessing.
Justice Doherty, when the Franks had the 3 vehicles on the policy, there was no stacking. They had waived it, so they were not paying for stacking. When they deleted the policy, they could have paid for stacking across 2 vehicles at that point, which would have been a premium that they would have paid, Justice Donahue, had they been given the opportunity to waive, which they were not given.
I hate to get into reality, but there was a point in time when they only owned 2 vehicles, and they didn't purchase stacking on those 2 vehicles. So then they purchased a 3rd vehicle and they opted out of stacking, and then they delete a vehicle, and your scenario is somehow under this circumstance they would now opt to have stacking.
In fact, Justice Donahue, I would say that it's more likely that one would stack when it becomes more affordable.
But there was a point in time when they only had 2 vehicles and they didn't purchase stacking.
That's true. That's true. At the time,
And it was more affordable under those circumstances.
it could have been, Your Honor, that was in 2014, or that was in 2013 when they had 2 vehicles on the policy, some years earlier, but circumstances changed. Their circumstances could have changed. And purchasing stacking on 2 coverage could be something that...
Isn't that the key, though? I mean, in order to hold in the manner in which you're arguing, we would have to read purchase to mean any change in coverage. I mean, that's the essence of your argument. Anytime there's a change in coverage, you have to have an opportunity to re-up for stacking benefits. But it's not what the statute says. It says purchase.
That's correct. That's correct, Justice Donahue. The statute is purchasing UM/UIM coverage, but the change in the rationale for holding that it is a purchase, consistent with Sackett and Barnard, is because there is a change. So there's something new.
Well, but
This is
the
what-
new part, though, excuse me, Chief, the new part is that they added a vehicle, and by virtue of adding a vehicle, purchased UM/UIM on that new vehicle. My concern with your argument is it doesn't track the statutory language. You keep talking about because they had a ability to purchase stacking at a new price because they went from 3 to 2, that triggers the statute. But that's not what the statute provides. It says each named insured purchasing, that's an active verb, purchasing uninsured or underinsured motorist coverage. They did not purchase underinsured or uninsured motorist coverage as a result of dropping this vehicle. There's nothing in the statute about opportunity, ability, stacking, It's an event of a purchase of UM/UIM coverage. Tell me how the dropping of this vehicle constituted a purchase of UM/UIM coverage on the other two vehicles.
It constituted a purchase, Justice Brobson, because this court defined a purchase as the acquisition of something you didn't have before, coupled with payment. That's the precedent from this court.
I understand the precedent. I'm asking I'm going to the statute. Each named insured purchasing UM/UIM motorist coverage. At what point did your clients purchase UM/UIM motorist coverage such that the notice under the statute is required?
They purchased UM and UIM coverage on a two-car policy when they deleted the third car, Justice Brobson.
So I should ignore the stipulated fact that you paid nothing, that the UM/UIM coverage on the two vehicles did not change as a result of dropping the car, because that's a stipulated fact in the record.
For just the UM/UIM coverage without stacking, Justice Brobson?
I'm not talking about, see, this is again, you keep talking about stacking. The statute doesn't talk about stacking, it talks about when notice is required. And it doesn't say anything about notice is required when there's a new opportunity to purchase stacking. It says notice is required when the actual insured purchases UM or UIM coverage. And it's a stipulated fact in the record that at the time of dropping the vehicle, there was no alteration of the UM/UIM coverage on the two vehicles that remained on the policy. So with that, I'm trying to understand, I'll give you one more chance at this. When did your clients purchase UM/UIM coverage for more than one vehicle such that the notice was required under the statute?
I would argue, Your Honor, Justice Brobson, that when the purchase, unless you either go back to the initial purchase, which Barnard and Sackett and the courts have explicitly said, and rejected the dissent's argument in Sackett that it's at the initial time, which I believe is what you're getting at, Justice Brobson.
No, I'm just trying to understand. Your argument is by dropping the vehicle, the notice was required. I'm asking you to tie that event to the statutory language. When they dropped the vehicle, when did they purchase UM/UIM coverage for more than one vehicle such that the notice was required?
I would argue, Justice Brobson, that they purchased UM and UIM coverage on two vehicles when they deleted the third vehicle.
Let me test that. Suppose I walk out of here and I walk by a Verizon or AT&T store, and there's a big sign in the window and it says, buy a cell phone plan and we'll give you a free phone. Now suppose I already have a 3-line family plan. Can I walk into the store and say, I'm canceling my third line, now give me a free phone? Seems to be what your argument is.
If, Justice Wecht, you're talking about if you already have 3 lines with AT&T, and you go in and you say, I want to drop a third line and add a third one to get a new...
Right, like you going from 3 cars to 2 cars and saying, I made a purchase.
Well, I believe that
Give me the stacking.
It's still a change.
It's
That's
still
what you're arguing.
well, it is still a change, Chief Justice Todd, but you've
Did
deleted...
you buy a plan? Did you buy a plan?
To get the free phone, under your analogy, Justice Wecht, you would have to buy a plan. You would have to buy the third line, you get the free phone, as I
You had
understand.
the third line. You said, give me my free phone because I'm canceling my third line.
Correct. So as I understand your analogy, Justice Wecht, you're saying you cancel the third line and then repurchase a third line to get the free phone. That's the Pergolese case, essentially, where...
No, you didn't. You just said, I'm canceling my third line, now give me my free phone. But you already had the family plan. Where's your purchase?
I think I understand your analogy now, Justice Wecht. You were saying that because you already had the third line, you want a free phone.
No, because under your reasoning, when you walk into that store and say, cancel my third line, that's a purchase. Now you're entitled to your free phone because you canceled a line.
Well, in that case, there would be no acquisition of something you didn't possess.
What did your clients acquire that they didn't possess? It seems the only thing they acquired was a reduction in premium.
So the key difference, I believe, in the analogy, Justice Wecht, is here the ability to purchase, it's a purchase because they had the ability to acquire something they didn't have before, which is the ability to purchase stacked coverage on two vehicles.
Counsel, I think we understand your argument, but before we wrap it up, do you want to address Judge McCaffrey's dissent in the Superior Court?
Only in that the dissent, the rationale for the dissent is that deletion of the car from the policy means that nothing was obtained that they didn't already have. And as I hoped I tried to make clear and articulate at the beginning of my argument, that reasoning is flawed because there is something here that they didn't have the ability to have before, which is stacking on two cars, because the statutory scheme is binary. Had they had the ability, Chief Justice Todd, to purchase stacking on two cars, even when they had three on the policy, then the appellee's argument and the dissent would make sense. But they didn't have that ability. This is something new for the Franks, the ability to purchase stacking on two cars. I believe that's why the dissent and the appellee's arguments are, the reasoning is flawed on that.
All right, any other questions from the justices? Thank you, sir.
Thank you.
Good morning. May it please the court, my name is Sandra Hemrick, and I represent the Appellee State Farm Mutual Automobile Insurance Company in this matter. As Justice Todd said at the outset of this argument, this case presents a single issue: whether the removal of one vehicle from a policy that insured three vehicles and was issued with non-stacked UIM coverage constitutes a purchase of UIM coverage under Section 1738C, thereby requiring the insurer to obtain a new stacking waiver. Based on the plain language of the statute and this court's decision in Barnard that interpreted the word purchase using the plain ordinary meaning of that word, the clear answer to the question before the court is no. Removal of a vehicle from a policy is clearly not a purchase of UIM coverage, and therefore there's no new waiver required.
What about counsel? What about their argument based on Judge McCaffrey's dissent below that we should construe purchase to mean a change, and that given the new reality, they're entitled to make that stacking decision anew. Is the statutory language not broad enough to encompass that definition?
It is not, Your Honor, and I think that, and Your Honor, I recall that you actually were the author of the Barnard decision. I think the Barnard decision makes very clear that the statute is not broad enough to encompass that. I mean, this court has repeatedly recognized, particularly in the context of the motor vehicle financial responsibility law, that the court is bound by the language of the statute where the language is not ambiguous. And this court has found at least twice that Section 1738C is not ambiguous, both in Barnard and in the Sackett 1 case. And in Barnard in particular, the court said that invocations of and arguments about public policy cannot override the plain language of subsection 1738C, nor can they contravene the plain meaning of purchase. Purchase doesn't mean change. Purchase, as this court explicitly held, means acquire something by paying for it. And the plaintiffs here, the Franks, they didn't acquire UIM coverage. I did want to address actually that specific issue. So the court actually says in Barnard, in order to satisfy the first of that two-pronged test for what is a purchase, the acquisition of something by paying for it, the court said the insured must obtain something she does not already possess, and specifically, and this is from, again, the Barnard opinion, in the context of subsection 1738C, an insured must obtain UIM coverage. So it's not this sort of abstract opportunity to buy something. That's not a purchase. That's not acquiring anything. The statute doesn't refer to the purchase of an opportunity. The statute refers to the purchase of UM or UIM coverage. The plaintiffs here, the Franks, did not purchase, did not acquire any UIM coverage they did not already have. As several of the justices pointed out during the first part of the argument, they already had UIM coverage on the 2 vehicles that remained on the policy. That coverage didn't change. They didn't pay anything to drop the 3rd vehicle from the policy. They did not acquire any UIM coverage.
Counsel, if we change the facts a little bit, though, so you would agree that if, in conjunction with dropping the 1 vehicle, they augmented the UM coverage on the 2 vehicles, that would constitute a purchase that would trigger a new notice?
Under Barnard, yes, that would constitute a purchase.
What if they reduced their UIM coverage on the 2 vehicles? Would that trigger the notice? It clearly isn't a purchase, but it does alter the UIM coverage. And would that, and again, I'm stuck with the statutory language. It sticks in my face. It isn't a purchase, but it seems to me to be a little closer to something that the General Assembly, if we look past the clear and unambiguous language of the statute, which we can't, might be something that the General Assembly might be like, wow, that might be also an opportunity to get a notice.
And had the General Assembly considered that, maybe they would have used the word change instead of the word purchase in the statute.
But it would have to be a change of UIM coverage, yes, and not like you said, sort of an opportunity to reassess your prior stacking decision.
Exactly.
But that's very interesting, I think, just to follow up on that. So, given that the salience of the word purchase in subsection C, supposing, to vary Justice Brobson's hypothetical, supposing they were on a plan X for 3 vehicles, and now they go to their State Farm agent and they say, we're thinking about going down to 2 vehicles. And he says, well, we've got this new plan, Plan Y, maybe you should purchase that. And they purchase that. Even if their premium's lower, that might be a purchase requiring an opportunity to waive stacking, right?
I would say if the coverage doesn't change, if they've still got the same, they haven't added a vehicle and they haven't increased the limits of the existing coverage, if they're simply paying a lower premium, I don't believe under Barnard that would constitute a purchase. They haven't acquired something they didn't already have, and they haven't paid for it.
In Justice Weck's hypothetical, they're purchasing a new plan.
If it's a new policy, if they're getting an issuance of a new policy, then
they're purchasing new coverage. I think that's kind of the point of my hypothetical, which I think Justice Weck, extended rightfully, which is if my original policy had certain limits for UIM on the 2, and I decided to reduce those limits when I dropped the vehicle, I think an argument could be made that is a new purchase of UIM coverage. It's different coverage, and it may mean that I'm getting a credit on the policy, I may be paying less, and this is all very interesting. It's not your facts.
Right, I think
it's very interesting, but I think that would be closer to a purchase. Here, the problem is it was stipulated in the record there was no change.
That's exactly right, Your Honor. That's exactly
Getting back to your case.
Yes.
Although we love hypotheticals, would you give us your analysis of Judge McCaffrey's dissent in the Superior Court?
Yes, Judge McCaffrey's dissent, I believe, really boils down to the way I think it was you, Justice Todd, who summarized plaintiff's position, might have been Justice Donahue, summarized plaintiff's position here, the appellant's position here, as any time the total sum of the potentially available stacked limits changes, you have to have a new stacking waiver. That's the position of the Franks here, and that's essentially, as I read it, what Judge McCaffrey was saying.
So you have to equate purchase with change.
Exactly.
In order to make his dissent the reality here.
I believe that's correct. I think that was the position that Judge McCaffrey was taking, was you can't, he was really going past the plain language and past the word purchase and really stretching the word purchase. It would really stretch the word purchase beyond any kind of rational, ordinary meaning. It would
And I take it from his
into.
perspective, the majority was too narrowly defining purchase.
I believe that's correct. I also think that Judge McCaffrey, to some extent, really sort of jumped over the plain language piece and right into the policy arguments, which, as this court has recognized, is not, and as the Statutory Construction Act says, is really not the way that a statutory construction question should be approached. The Statutory Construction Act says you start with the words of the statute, and if they're clear and ambiguous, then you apply the ordinary meaning of those words.
And
it's only
there's
if you...
there's no ambiguity here in your estimation.
Absolutely, and again, this court has found at least twice that there's no ambiguity in section...
That argument also requires us to ignore Barnard. Because,
Absolutely.
I mean, Barnard did not say change. That would have been an easy way to decide all of these cases.
Yes, exactly.
However,
exactly.
we didn't.
Right, if you subbed in the word in subsection C, changing in for purchasing, or increasing or decreasing instead of purchasing, you'd be in a different
Right.
situation.
But as we've said, that's not the way that the legislature wrote the statute.
Well, in this case, I don't think we would be in a situation because there was no change of UM/UIM coverage for the two vehicles. There was no increase of coverage for it, and there was no decrease of coverage for it. So any way you look at it factually.
I would say that's correct. Judge McCaffrey's dissent, as I recall, looks at not the change on the coverages on the on the individual vehicles, but the potential change in the total.
Of the policy.
And so, yes, and so that was Judge McCaffrey's view.
Do any of the justices have anything further? If not, we thank you for your time.
Thank you, Your Honor. It's been a pleasure.
Commonwealth of Pennsylvania versus Jonathan Rivera. Representing Mr. Rivera, Ms. Lisa Matthewson. Representing the Commonwealth, Mr. Albert Andre.
Good morning. The appellant in this case was charged with numerous sexually based offenses that involved 4 minor victims over a 10-year period. At trial, the Commonwealth asked one of the detectives involved in the case whether, after being arrested and read his Miranda rights, appellant denied the allegations against him, and the detective stated that he did not. On appeal, appellant argued that this questioning violated his federal and state constitutional right to remain silent. The Superior Court determined that the questioning was improper, but held that the error was harmless because at most it resulted in de minimis prejudice. We granted review to consider whether the Superior Court's finding of harmless error was erroneous in view of the fact that the court apparently relied on case law that pertains to determinations of prejudice resulting from references to a defendant's pre-arrest as opposed to post-arrest silence. Is that about right?
It's a complicated issue, Your Honor, and Your Honor handled it admirably. Thank you. Your Honors, Lisa Matthewson, representing Mr. Rivera. With me is Attorney Christopher Powell, who was trial counsel. May it please the court. As Your Honor points out, it is undisputed that Mr. Rivera's constitutional rights were violated when the prosecutor repeatedly asked the arresting officer whether, in response to arrest and Miranda warnings, he had denied wrongdoing or had invoked his right to remain silent. And the officer explained that he did the latter. For 50 years, the court has recognized that jurors inherently will infer guilt from references to post-arrest silence. That is, these references are inherently, quote, prejudicial. And the court uses the term prejudicial to mean that they burden the constitutional right. That is, they invite the improper inference. Because they burden the constitutional right, they are error. So when the Superior Court found that there was error, the Superior Court necessarily found that the testimony invited the improper inference. Properly applied, then, this court's precedent required the Commonwealth to show that that error was harmless beyond a reasonable doubt. That is, that it could not have influenced the jury's verdict. Instead of applying those decades of precedent, which would compel reversal on this record, the Superior Court affirmed, and when it did so, it created three problems. First, it redefined the harmless error standard with the standard for determining whether the use of pre-arrest silence is error at all. Second, it collapsed the substantive rules between pre-arrest and post-arrest silence, and therefore undermined the substantive rights. And third, it actually expanded the narrow lane that the court's plurality opinions in the Adams case created, giving prosecutors leeway to use pre-arrest silence in a way that doesn't raise an inference of guilt. And it, in so doing, and in treating the questioning here as, quote, contextual and brief and merely narrating the course of the investigation, what the Superior Court did was essentially give prosecutors carte blanche to introduce comment on not only pre-arrest, but also post-arrest, post-Miranda silence, as long as they can justify it as course of the investigation.
Just to simplify your argument right here that you've made so articulately, is basically the Superior Court utilized pre-arrest silence cases in a post-arrest silence case.
Yes, Your Honor, with one addition to that, because what they did was not only use pre-arrest silence cases, but use pre-arrest silence cases on the topic of whether there's error at all to control harmless error from an acknowledged violation in a post-arrest silence case.
So I suppose that it's your position then we shouldn't even get to that issue.
To the issue of whether the error was harmless?
Correct.
Your Honors, I do submit that this court both can and should reach the question of whether the error was harmless, and this is why. First, there are decades of this court's precedent that show that when the trial is a credibility contest, it is not possible to say that this highly prejudicial evidence did not affect the verdict. It's not possible for the court to say that beyond a reasonable doubt. That doesn't mean it's structural error, as the Commonwealth suggests. It is not. This court has and does affirm, as does the Superior Court, even in cases where the Commonwealth has improperly been permitted to comment on post-arrest silence.
Doesn't your argument that we should get to the issue of harmless error counter against your position as to the sanctity of post-arrest silence?
I'm not sure I follow, Your Honor, because the Superior Court did hold that there was error here, and the Commonwealth did not seek review of that issue. And so given that there was a holding of error, the question is whether the Superior Court correctly applied the harmless error standard, but their mistake on harmless error, Your Honor, has this cascade of effects that gets into the substantive distinction between pre- and post-arrest silence and even threatens the Adams line. Your Honors, there are decades, again, of precedent that require reversal here where the evidence was equivocal. There was a split verdict. My client was acquitted of the most serious offenses. There are, the Turner case itself was a single question, unanswered, withdrawn, curative instruction, never mentioned again, but the court reversed because when credibility is the key issue, as it was here, it's impossible to say the jury wouldn't be influenced. Costa, single question, no additional reference, reversed. Clark, one-word answer, question withdrawn, reversed. Greco, a single reference, elicited inadvertently, the court reversed. So the court certainly, the record is clear enough and the precedent is clear enough that this court can order a new trial. And here's why I say, Your Honor, the court should order a new trial. Several layers to that answer, actually. First, the fact is, again, the precedent is clear. Second, the Superior Court, we spent about 21 months in the Superior Court, and were this court to remand for application of the harmless error standard, there is both a public interest and Mr. Rivera's interest in a prompt retrial. We're only seeking a retrial, not judgment of acquittal, that would be impaired, given, of course, the child victims, the severity of the accusations, and the fact that my client's incarcerated. There's no need to remand to the Superior Court, given the precedent and the record. Second, I will note that Your Honors, of course, have the Hamlet case in mind, and the Superior Court referenced the Hamlet case because the Commonwealth really made no effort in its Superior Court briefing, other than a sort of generalized, uncited reference to harmless error. The Superior Court said, but we can look at this. It wasn't entirely sua sponte, because the Commonwealth at least asserted that there was harmless error, but the Superior Court, lacking true adversary briefing, actually went into the overwhelming evidence standard, which the Commonwealth had not raised, wrote an opinion that relied on overwhelming contradicted evidence. I filed a motion for re-argument and said, you can't do that. You have to limit it to overwhelming evidence that was uncontradicted, of course, as the court knows, under Fulton and other precedent. They granted re-argument, and then they tried again. And they came up with another theory that the Commonwealth had not raised, which was that the Adams case and DeNicola's contextual and brief reference for pre-arrest silence can control the harmless error standard from post-arrest. And as the court knows, they literally called Adams a harmless error case. And having done it, they said post-arrest silence, harmless error case, Adams, which it isn't. And then they went ahead and used the standard from Adams to control harmless error. I filed another application for re-argument, Your Honors, which looked a lot like my petition for a la carte to this court, and the Superior Court declined to revisit the issue. So I
don't know what you want us to do, to be honest with you.
Yes.
I would understand your argument is if you were saying, given the innate ambiguity of silence and the improper use of that by the prosecution, the error cannot be harmless. Okay, that I would understand. Mm-hmm. That's not where your argument is. You are arguing that there is some application of harmless error. How is that? How are we going to clarify the law in this? I mean, you're saying that the Commonwealth would have to establish beyond a reasonable doubt that it didn't impact. I'll be honest with you. I don't know how that is distinguishable in a practical sense from the application of one of the three possible harmless error analyses that we use in other contexts. So help me. I mean, if you're standing here saying, given the innate problem with the use of post-arrest silence by the prosecution, the error cannot be harmless, because you're saying it's innately prejudicial. Okay, it's innately prejudicial.
Please
so
allow me
what do you want us to say the harmless error standard is in this context?
Thank you, Your Honor. And I do need to clarify this because it is something that, honestly, the Commonwealth brief was illuminating on when I realized that the confusion arises around the term prejudice. Prejudice in this context means inviting an inference of guilt. That comes from the Chapman case, when Chapman says admitting highly prejudicial evidence casts on the burden other than the person prejudiced by it to show that it's harmless beyond a reasonable doubt. And when the court adopted that in Story, and of course the court must, given that federal rights are also implicated here too, the court recognized and maintained that reasoning. Prejudicial does not mean requiring reversal here. And I'll get back in a moment to where it does.
What is harmless error then? Answer that question. I mean,
the harmless error standard is the harmless error standard that the court adopted in Story. And that standard is applied in Turner, Costa, Clark, Greco, and a legion of cases. does require reversal on this record. But, Your Honor, I'm not asking the court to...
Articulate for me what that standard is.
Absolutely. So the Commonwealth must show, beyond a reasonable doubt, that the highly prejudicial evidence, the improperly admitted comment on silence, did not affect the verdict that this jury rendered.
Okay, so let me ask you this question. If they
Yes.
showed that the properly admitted and uncontradicted evidence of guilt was overwhelming,
If they
Does
were
that
able
get
to
them
do
there?
that, Your Honor, absolutely. But the Superior Court has already...
I'm testing the theory that there is some distinction between this harmless error standard that you're arguing and the harmless error standard that we apply in other harmless error cases where prejudice is not innate. Okay, so if they showed that the properly admitted and uncontradicted evidence of guilt was overwhelming, that would get them where they needed to go.
Yes, Your Honor, and please allow me to clarify as well. I'm not arguing for any distinction in the harmless error standard. When I say prejudice is innate, and that is a phrase I'm taking from the court's case law, prejudice is innate because the reference to silence innately raises an inference of guilt when the silence was post-arrest and, of course, under federal law post-Miranda.
Be overcome beyond a reasonable doubt by the other evidence in the record.
It can be, Your Honor, if that evidence is uncontradicted. And the court's the Wright case was a reversal on that basis. The Mitchell case was a reversal on that basis. There are myriad cases in Superior Court that have reversed on that basis. And to get back to Justice Donahue's point about prejudice, because this is confusing and in all candor, the case law is not perfectly consistent in the way that it uses prejudice sometimes. But prejudice in this context just means it counts against the defendant. So when it's post-arrest silence, this court has said since Turner, really since Greco and even going back before that, of course, lay jurors will infer guilt. So the question the court asks when it's pre-arrest silence, the question Molina and Adams tackled, sometimes it raises the inference of guilt, sometimes it doesn't. That doesn't apply to post-arrest. Post-arrest always raises that inference of guilt. Now, to Your Honor's point, harmless error is simply asking whether this evidence that raises the inference of guilt, that's the innately prejudicial part, just the harmful inference. Is it possible to say that it didn't affect the jury's verdict? And to Justice Dougherty's point, absolutely it is, and the court has done that repeatedly.
But not here, but not here.
But not here.
And what criteria, just to follow up, what criteria do you want us to use, to direct trial courts to use here?
Your Honor, the criteria that the court prescribed in Story and reiterated in Fulton and has summarized in various cases as either de minimis prejudice, which really doesn't apply when it's post-arrest silence because that inference of guilt is inherent. Overwhelming uncontradicted evidence will allow affirmance, or if the evidence is cumulative of properly admitted evidence. Now, I respectfully submit that comment on silence will never be cumulative of properly admitted evidence, but I'm not arguing for automatic reversal.
So that's where I think the clarification. This case has become very simple in my view based on your argument. You're not asking for a per se. I think it's not before us the question of whether there was a violation here. Where there was a violation. Everybody, that's decided in this case.
Correct.
The question is remedy, and you're not here arguing for a per se reversal when there's a violation. You're not arguing against application of the harmless error doctrine.
Correct. I'm saying that the Superior Court got the harmless error standard wrong.
But again, you say the harmless error standard, but if you go by what the harmless error standard, the three options, should be able to be easily applied here. One, is it, I think the Superior Court said it was de minimis, citing the pre-arrest cases. I'm not sure that's right. I'm not sure whether it's innately prejudicial or whatever, but I'm not sure a constitutional violation could ever be considered de minimis. So for that reason, I think there's probably prejudice. The second prong is cumulative. We don't have that either. So the only way we could conclude that this is harmless error is under the third option, which Justice Dougherty pointed out. Overwhelming, uncontested evidence of guilt. Where is it?
It's not here. And the Superior Court already agreed with me on that because the Superior Court's first opinion, the March opinion that's in the Appendix B, Their March opinion, they said the evidence was overwhelming. And just as the Commonwealth does in its brief here, they detailed all of the prosecution evidence. On re-argument, I pointed out that the court is limited to uncontradicted evidence, because otherwise that would put the appellate court in the position of making credibility determinations and essentially equate with sufficiency of the evidence. The Superior Court agreed, granted re-argument, and then issued a second opinion in which they took another attempt at harmlessness with another argument the Commonwealth hadn't raised, and that was using the pre-arrest silence cases to govern harmless error.
To conclude that it was de minimis.
To conclude that it was de minimis, but let me also, again, this is the problem of, as the court is considering what does and doesn't need to be clarified here, I respectfully submit that the use of the term prejudice has created a lot of confusion. When the Story case talks about de minimis prejudice or no prejudice, again, that is referring to evidence that raises no inference of guilt. If prejudice in that context meant no effect on the verdict, then the rule would be it's harmless whenever it's harmless. When Story says prejudice or de minimis prejudice, what it's referring to is, did this hurt the defendant? And, of course, because this court uses that beyond a reasonable doubt standard in both constitutional and non-constitutional cases, you may have, under that standard, for example, let's say business records that were admitted without authentication. That's an error, but if those business records aren't harmful to the defendant, that's an error that carried no prejudice or de minimis prejudice. And so under the harmless error standard, because those business records raised no inference of guilt, their admission was harmless. But that does not allow, and as Your Honor intuited, in the constitutional context, the very definition of error is that the evidence burdened the exercise of the constitutional right.
Counsel, I'm still listening or thinking about your comment that prejudice is the inappropriate word. What descriptor do you believe we should incorporate then?
I think prejudice works defined as burdening the exercise of the right, or more generally in the non-constitutional context, raising an inference of guilt. If Your Honors, prejudice is an accepted term, and in fact it's the term that the federal courts use, and it's the term that this court has used from Story on forward, and including in Turner and in this context. Prejudice is fine, Your Honor, as long as everybody understands that prejudice means raising the inference, yes. It does not mean determinative or affecting the verdict, and so it's not an argument for structural error. But there's one other point to be made on the prejudice term, because it goes to your point, Justice Dougherty, of what other clarifications may be needed. Prejudice is also used to mean effect on the verdict in the ineffective assistance of counsel context. And this is where we get the confusion from the DeNicola case, and even Commonwealth v. Whitney before it. DeNicola was the first time that the court said the mere mention of silence is not innately prejudicial. Now, to begin with, that's talking about pre-arrest, not post-arrest. But crucially, that's also talking about ineffective assistance of counsel. And if Your Honors review the DeNicola opinion, you will see that this is the second part of the opinion where they say we need to figure out whether it was ineffective for counsel to fail to object to the use of the defendant's pre-arrest silence. And the court says we actually don't even really need to deal with that because it's not prejudicial. Prejudicial in that context means the burden is on the defendant to demonstrate that it did affect the verdict.
Counsel,
yes.
Let me play devil's advocate with your theory. So if we are to perceive the inference of guilt to be overwhelming and not beyond a reasonable doubt, in our analysis, when we're looking at the other evidence, can we consider that despite this introduction of the singular comment from the prosecutor that the jury returned a verdict of guilty only on 11 out of 22 charges? Would that not confront or conflict with your opinion that it's innately prejudiced?
It would not, Your Honor, and this is in fact the point that the Commonwealth argued in the Turner case. The Commonwealth made this exact point, that the fact that the jury delivered a split verdict shows that they were not overwhelmingly influenced by. They're wrong, Your Honor, because on appellate review, the court cannot assume that the other evidence that the jury would have accepted the credibility of the prosecution's evidence. The court can't assume conviction and figure that the split verdict shows that there was something else that raised a doubt. What the court has to do is start from the proposition that this is not a question of sufficiency of the evidence. I'm sorry?
We're looking at the innate prejudice, the influence of it.
Yes.
We're not looking at the Commonwealth's burden. So your argument is saying the Commonwealth's wrong because we shouldn't be looking at their burden, which resulted in X number of conviction because we don't know. That's not standard. That's not even before us. We're looking myopically at, did this introduction of this statement so innately and constitutionally prejudice your client? And the question I have is, how are we to take that introduction of prejudice, and how are we to balance the evidence before the court as well as the evidence that the jury came back with 11 out of 22?
Two things on that, Your Honor. That's exactly what the court's not supposed to do. Appellate courts cannot balance the evidence and weigh one against the other. But that's why...
Let's stop there. Then how are we supposed, as Justice Donahue said, how are we supposed to look at and judge a harmless error beyond a reasonable doubt standard if we're not looking at the evidence?
Because, Your Honors, the question is there any scenario under which, again, beyond a reasonable doubt, that this did not affect the verdict?
And I'm asking...
And that's why, in the Turner case...
But you said it's not our job to weigh the evidence.
Correct.
I'm asking you, what is our job when we have to determine, based upon a cold record, whether harmless error was established beyond a reasonable doubt?
The court's job is to first, let me take a step back and say, because it is beyond a reasonable doubt, the court has to ask, is there any possibility the jury was influenced? And time after time after time, the court has said that when credibility is at issue, it is impossible to say beyond a reasonable doubt that the jury was not influenced.
Are you claiming that when credibility is a primary issue in the case, there can never be harmless error, or when credibility is the only issue in the case, there can never be harmless error?
Your Honor, they probably come to the same thing because the defense view will always be that, and of course this is just how juries make decisions, they will weigh the credibility of the defense narrative. But to Your Honor's point...
There could be so much other evidence,
Right.
though, DNA, eyewitness, whatever, that the credibility determination would not control the harmless error analysis. Would you agree with that?
True, Your Honor, and that would be your overwhelming uncontradicted evidence
And
case.
that's
Now,
what distinguishes it, sorry, that's what distinguishes it from structural error.
Yes.
Why you're not,
yes,
that's
Your
why
Honor.
you're not
Yes.
going there.
Absolutely, absolutely. So, but let me just talk here about the record for a moment, and that is the concept that the evidence was overwhelming here simply has no basis in the record. This was an amazingly hard-fought case. The mother of one complainant testified for the defense. There was, and said that the mother of another complainant had improperly influenced the complainant's statements. The physical evidence showed absolutely nothing. There was no corroboration whatsoever. There was no prompt complaint. There was not only the defendant's testimony, but again, the mother of one complainant testified for the defense about the improper influence. And when cross-examined, the arresting officer acknowledged that he knew nothing about motives to lies that had come into the record otherwise, that there were, in fact, a contested divorce proceeding, there were disputes over money. Your Honor, the mother of one of the mother who really led the reach out to the police here, and the one who had audio taped the children before law enforcement even got involved, held a rehearsal, one of them agreed. That mother admitted on the stand that she had told her sister that accusing Mr. Rivera of a sex offense would help them get legal status in the United States because they were here illegally. This could not have been a more hard-fought case.
Well, was there no evidence other than the credibility evidence? Was there no evidence other than that?
There was none. There was
established guilt?
no physical evidence, Your Honor. None. Literally none. Of course, the Superior Court at one point referred to the forensic interviews, but the forensic interviews were simply derivative. It was simply that, and that was after the mother, Florencia, referenced in the papers, had already questioned the children and made tapes that the officer told her to destroy later, and then she didn't. There was a whole heck of a lot going on here, Your Honors. There were two pieces of evidence that were uncontradicted, I will say. One, of course, the nurse examiner testified, and the defense emphasized, that the physical findings were negative for abuse.
And we know that's not conclusive.
Of course, it's not conclusive, but it's also not beyond a reasonable doubt. The other piece that was uncontested was testimony of the paramedic that Mr. Rivera was present on the night that the child known as GR was choking on the lollipop. Also uncontested, in fact, the paramedic said he very likely saved her life because he was trying to give her CPR before the paramedics arrived. Those are the two pieces of uncontradicted evidence. So if Your Honors look, for example, at the Young case, the Young case is one in which the only evidence that was uncontradicted was testimony that the defendant had moved to Idaho. Looking at that by itself wasn't going to get anyone anywhere. So if Your Honors, consider the only uncontradicted evidence here is the negative findings on the forensic exam and the paramedic who testifies that Mr. Rivera may have saved the child's life when giving her CPR when she was choking on a lollipop. That is not sufficient to meet the harmless error standard.
The trial court mentions in his opinion that he felt that any prejudice was resolved in part by the defendant's own testimony. When your client testified during the course of his trial, did he talk to or address the issue of his silence?
He did not, Your Honor. And the trial court's reference there is interesting because he was referring to, of course, the right to testify at trial, and I believe he also referred to jury instructions that the defendant need not testify at trial, even though, of course, he ultimately elected to do so. But the fact that he testified is important here, of course, because what happened, the sequence here, is before he even took the stand to give his version of the facts, the Commonwealth had undermined his credibility before he even got up there, because the jury knew that no matter what he said there in that courtroom, he had never told the police that he didn't do what he was accused of. And so the Commonwealth really preemptively undermined his testimony. And Your Honor sees, of course, in cases like the Doyle case itself and in Turner, those are cases where the defendant is on the stand and he is personally cross-examined with his prior silence, post-arrest, post-Miranda, and those cases still say that it's error and still require reversal. And in fact here, this is really an a fortiori type situation because this was in the Commonwealth's case in chief. This was substantive use of guilt, and the way it unfolded was—
Well, but counsel, just to be
Yes.
fair though, it arose on redirect examination of the trooper following a cross-examination where the thoroughness of the investigation was challenged on cross-examination.
Yes.
You're kind of getting into that fair response question, which I don't think is before us. So I'm not sure why you're getting to this point. It's the cross-examination challenged the quality of the investigation pre-arrest, and then on redirect examination by the prosecutor, they asked about post-arrest silence.
Yes.
We know that.
And, Your Honor, the fair response question certainly is not before the court in terms of error, but it is something that the Superior Court used to say harmlessness. And that's really the irony here. It's where we see how undermining the harmless error standard actually undermines the substantive rules. Because they recognized fair response is off the table when it is post-arrest, post-Miranda. Only if there is a blatant factual inconsistency, that is in the federal cases, and then this court says the same in Turner and cites that Doyle footnote number 11. Only a blatant factual inconsistency allows the use of post-arrest, post-Miranda silence. The Superior Court recognized that and said, citing Turner, okay, it is error, this did not open the door. But it basically undermined that very rule then by using the same Rule 403 fair response analysis from De Nicola to find the error harmless. It simply doesn't apply in post-arrest, post-Miranda, and it is confusing a standard for determining whether there's error at all with a standard for determining whether the error is harmless. And please, if I may, Justice Robson, just to go back to your point about why I was emphasizing that, and to your point of the cross-examination. The reality here is that cross-examination scored points. And that cross-examination scored points on the inadequacy of the pre-arrest investigation. Now, as an aside, when a defendant challenges the adequacy of the pre-arrest investigation, that's essentially challenging guilt. It's challenging the Commonwealth's conclusion that he's the perpetrator. So if challenging the pre-arrest investigation opens the door to the use of post-arrest, post-Miranda silence, then a defendant is being told either don't challenge the Commonwealth's case or accept that your right to silence goes out the window in, quote, fair response.
But now you're
No one's
getting back to
arguing that.
error as opposed to our focus here is on the harmless error analysis.
Well, this inquiry should be limited to error, Your Honors, but the Superior Court used it on harmlessness. And that's why it is vital that the court correct this. The court said the court referenced this very concept in the Taylor case, the heads I win, tails you lose phrase from the Taylor case, where the court pointed out that if a juvenile is contesting certification on the Superior Court's analysis there, that was enough to put his silence in issue. It's the same thing here. Mr. Rivera was contesting guilt. He was attacking that pre-arrest investigation. But if that opens the door to post-arrest, post-Miranda silence, then there's no way that that right survives. And Your Honor, of course, Chief Justice Todd, it's true. The Superior Court did not use that standard on whether there was error. But having used it on harmlessness had the same effect, because Mr. Rivera's convictions stand as a result of this improper use of silence.
All right,
And
I
what
think we have your argument, Ms. Matthewson. Thank you so
Thank you.
much. Let's hear from the Commonwealth.
Morning, Justices. My name is Albert Andre, District Attorney of Bradford County. I'm here on behalf of the Commonwealth. Excuse me. So, as noted, defendant kind of raises this whole thing by bringing up in its cross-examination of the trooper that you never talked to my client before you filed these charges. Youthful exuberance leads to the prosecutor asking the trooper, well, you did Mirandize him, and to my mind, that's a red flag right there, and defense should have, at that point, requested either a sidebar or something of that nature, because, you know where that's going.
Why shouldn't the Commonwealth prepare its witnesses and make sure that these blurting outs don't occur?
Well, there was no blurting out other than on the cross-examination for the trooper to first say, I tried to. He didn't really say when. It was on redirect that the prosecutor brings up. So it's actually a question directly asked by the prosecutor, which...
That's what I'm sorry to interrupt you, counsel.
Sure.
That was my point. You were faulting the defense, and my question to you was, looking at what happened here on redirect,
Sure.
I guess you called it youthful exuberance. Why do we not expect prosecutors in this Commonwealth to put in the time to remind witnesses not to mention the post-arrest silence?
Well, at that point, I think the prosecutor thought it was fair argument against the fact that the trooper was asked, he never talked to the defendant and got his version
But that's,
of the facts.
I mean, we can agree that's error, right?
No, it's error. Whether it's error that requires reversal is what we're here
Well,
about.
that's what we're focused on. We really are over the question of whether it was erroneous and a constitutional violation for that to be said. I think we all agree it was. So let's focus on the harmless error.
Well, in fairness, Chief, though, I think, Mr. Andre, you were leading with your waiver argument. Isn't that what you were trying to do?
That was one of my arguments, that the objection was just, he doesn't have to deny, and then the court said to the jury.
You're saying we should find waiver because there wasn't an ask for a curative instruction, there wasn't an immediate objection, that's your waiver argument.
Basically.
Okay. I think the Chief wants you to get to the harmless error argument.
Well, if you're finished with your waiver argument, yes.
So, well,
Were you
Superior
not
Court.
finished with that? I don't want to cut you off, sir. If you had more to say on waiver, please go ahead.
No, I think Justice Robson
Made your argument.
made my argument.
All right, let's proceed to harmless error then.
So obviously, there's different standards for harmless error. The Superior Court does cite this Adams case, which is a pre-arrest standard, but in their discussion, they do say the burden is on the Commonwealth, and they do find it to be harmless error, which brings the question, why are we here unless we're going to argue there should be a bright line prejudice for any reference in these matters, which defense is indicating that's not what they're asking for. They're asking for a clarification of the harmless error discussion, and that the Superior Court somehow, even though in their discussion they're saying they're applying the correct standard, they did cite a pre-arrest.
And that's totally wrong, right? I mean, it's a different, the Superior Court had two bites at this apple and blew it both times, didn't they? First they used contradicted evidence, and they were called on that, and then they had another shot at it, and then they used pre-arrest cases in a post-arrest case.
And that is kind of something that's difficult for me to address. I mean, obviously, it'd be easier if the prosecutor had not even raised that bridge or jumped into that bridge.
And one follow-up, counsel, if I may.
Sure.
How would you respond to opposing counsel's discussion that this case was all about credibility and therefore the error could not have been harmless?
Well, I think with these sex offense cases, there is a lot of he said, she said. I think there was, Ms. Matheson did mention the lollipop incident, and the key to that was that the child said, yeah, I was dreaming that the defendant was using the lollipop, and you could speculate that that was a type of grooming when that choking occurred, and that choking did occur, EMS there, that the choking did occur is kind of uncontradicted because there was other evidence of that. And I think a couple of the young witnesses kind of corroborated each other as far as details and things of that nature.
But what evidence was there of guilt other than the testimony which turned on credibility?
Well, there was the testimony of the 4 victims, there was the testimony of certain adults, there was the forensic interviews that were all consistent.
These are all testimonial, this is all testimonial evidence
Agreed.
that's subject to a credibility analysis. Anything other than that type of evidence?
Well, again, the incident with the lollipop and what that
Almost
was.
seems exculpatory to me, but.
Well, that he tried to save her, yes, but that,
There was no DNA, no
Let him
semen, was
finish.
there? I'm
Could
trying
he
to help
finish
him.
this? Yeah. He was finishing the lollipop analysis, yes.
right.
Go ahead.
So the lollipop, well, the child had said, yeah, and thought it was a dream that he was moving the lollipop back and forth in her mouth. That incident actually happened with the child eventually choking on the lollipop. That is kind of uncorroborated, or, yeah.
I'm sorry, Justice Stark.
That's okay. I have a question. Is your argument that the error was de minimis?
Well, basically, that it was again, something that the defendant brings up does not properly raise the objection. The court responds with agreeing with the defendant that they do not have to deny.
All right,
And that's never brought up again within the case. In cross-examination of defendant, it's not mentioned.
but you're arguing Justice Probson's waiver argument. I'm talking de minimis, because the question I have here, I guess, is our precedent in Turner talks about post-Miranda silence innately prejudicial.
Understand.
So how do you overcome our decision that any time one references post-Miranda arrest silence, it's innately prejudicial, and it's going to the core here, particularly when it is brought forth by the Commonwealth?
Well, in the later case law, such as Spots, Mitchell, they basically said it is subject still to a harmless error analysis here. So, and the Superior Court, in conducting that analysis, which
brings us back to Chief Justice's argument.
Right.
There's no uncontradicted evidence here with regard to proof beyond a reasonable doubt. No semen's found despite evidence that he ejaculated or things of this nature. It's all credibility. She said versus he said, correct? Yes or no?
I would have to say yes, but again, my argument of some of the corroboration of the
lollipop
incident
And
the witnesses corroborating each other.
in any case of this nature, the case can be won just on the basis of testimony. The defense can.
Right. That's what the instruction says. You can make a finding of guilt just upon the testimony of the victims.
The Commonwealth could carry its burden on that, but in this particular case, we have a constitutional violation with reference to post-arrest silence, and our focus really is on just the harmless error.
Yes.
And the waiver. I don't mean to overlook the waiver argument, but on the merits, we're really looking at the harmless error. And is there anything else you'd like to say about that?
Don't believe so, Your Honor. Thank
All
you.
right, thank you both very
May I
much.
just
Oh,
ask,
yes.
I'm sorry.
could you answer Justice Doherty's question? Do you believe that this error was de minimis?
I think given all the other evidence and the way the trial was conducted and everything, yes.
Was there a curative instruction?
There was just the instruction that when the defense said he doesn't have to deny, the court said, yes, under the Constitution, he does not have to deny. And
And
beyond that was it.
Did the prosecution argue in closing argument?
No.
Okay, so those two factors might suggest de minimis. You're a seasoned prosecutor. Do you believe that a prosecutor relying on post-arrest silence can ever result in a fair verdict from a jury? Once the prosecutor raises the issue of the post-arrest silence,
Right.
can that ever be purged from the case?
I think it can, because I think if you read juror questionnaires, they all say if the defendant doesn't testify or whatever, they would find them guilty, but hardly ever does that seem to bear any weight when they're sitting in trial. I mean, they say these things, but from my experience, they will still follow the court's instructions on those issues.
Thank you.
Thank you. Thank you very much.
No, I'm good, thanks.
In the interest of KT, a minor, appeal of KT, and Representing KT minor, Mr. Thomas Walshantz. Representing CYF, Ms. Diane McKay. Representing KST mother, Mr. Matthew Hammermesh.
In this case, the Allegheny County Office of Children, Youth, and Families, or CYF, filed a petition to voluntarily terminate a mother's parental rights. And the trial court denied the petition, finding, among other things, that severing the parent-child bond would have an adverse effect on the child. The Superior Court affirmed, and CYF appealed. The issue before us is whether the trial court applied the correct standard in denying the petition, and in particular, whether it appropriately weighed the impact that severing the mother-child bond would have on the child in light of other factors such as the child's need for permanence.
Thank you, Chief Justice Todd. Excuse me. May it please the court, my name is Tom Welshantz. Joining me today is Diane McKay. I am counsel for KT, the appellant, one of the appellants in this case. Ms. McKay is counsel for CYF, the other appellant. With the permission of the court, I would like to address what we see as the Orphans Court's errors in this case. Ms. McKay will be available to address the Superior Court's errors. I have 2 points that I would like to very quickly make at the outset. First of all, there is no dispute in this case that grounds for termination of mother's parental rights exist under Section 2511A. The sole focus in this case is KT's developmental, physical, and emotional needs and welfare under Section 2511B. The Orphans Court's error in this case was that rather than considering all of the factors that are required in a Section 2511B analysis, like, for example, the child's need for permanency, the trial court, the Orphans Court, denied the TPR petition based on the parent-child bond without considering whether that bond was necessary and beneficial for the child, or whether severing that bond would cause the child to suffer extreme emotional circumstances.
This extreme emotional circumstance, this is a new standard you want us to adopt in Section B analyses, isn't it?
I disagree with that, Justice Wecht. Our position is that this court in 1993 in the EM case, which was a different case, but it was a case that was focused on how the Orphans Court should consider bond in a termination of parental rights case. The EM case is where that extreme emotional circumstances language comes from.
But we also said in EM, we also used the phrase, quote, contrary to the needs of welfare of the child, unquote. So that remains the poll star under 2511B, doesn't it?
Needs and welfare is 20, that's the language from 2511B. To the extent, and I know that Mother and her amicus have argued that this extreme emotional consequences language is new. It's something that we are asking the court to create. We disagree with that, but to the extent that that issue is on the table, here's what I would say to you, is that at the stage of the case we are, which is we've satisfied 2511A, we're not at 2511B. The focus in 2511B is on the child. That requires a balance of a whole host of issues, including what I think we would all agree is a critical need for a child, which is a permanent, a forever home, someplace where they will be safe and stable and forever. What the Orphans Court did here was pushed aside all of those other factors. The Orphans Court focused solely on the bond, and it said that the fact that the bond could have that severing the bond could have any negative consequence on the child is enough to trump all of those other factors. Like
Counsel.
Yes, Your Honor.
Do I understand you to say that trial counsel, in its attempt to do what it thought was right, viewed 2511B through the eyes of the mother as opposed to through the eyes of the child?
Trial counsel or the trial court?
I'm sorry, trial judge.
I believe that the trial judge focused solely on that one issue, the bond. I think that there are so many other issues here that could be encompassed. And to get back to Justice Wecht's question, again, if we look at what should be the appropriate standard, If the bond is going to trump all of these other factors, like the fact in this case, the child had been in this home for almost her entire life. This was the family, this was the person she considered her mother. She was with her siblings. If that bond is going to cause this child to be left in limbo, because it's not disputed, reunification will not happen in this case. So if the bond will disrupt that, it should cause such a severe, extreme consequence to the child, because otherwise the child is left in limbo.
Counsel, I apologize again. I don't mean to interrupt you. I'm
Yes.
just trying to bring this forth so that I understand you. Your argument to us is that in a 2511B analysis, when you're looking at the developmental, the physical, or the emotional needs, there has to be more than just does child and mom or parent have a bond. We have to look at the alternatives, the innates, the love, the affection, the security, the permanency.
Absolutely,
And
Justice.
this judge did not do that, unfortunately, and therefore it's wrong.
Absolutely, Justice
I think we
Doherty.
got you.
That's exactly what I'm arguing. And
Counsel, can I just build on that? Because
course.
these cases always make me a little bit nervous, not the subject matter, but when we have a 1925 opinion, and we're drawing conclusions from the 1925 opinion about what the trial court considered or didn't consider. And the request you're seeking is essentially a vacate and a remand, right?
Your Honor, we're asking that the court reverse the decision of the Superior Court and enter an order directing the trial court to enter an order terminating mother's parental rights. We're saying that this is not a close call case. We're saying that the evidence was here, pardon me, the evidence
Well,
was...
that makes me really nervous to do that. But let's assume I'm not inclined to give you the grand slam. If in a lot of these cases when we have a 1925 opinion and we vacate it because the trial court judge didn't hit all the marks, didn't consider all the factors, and it goes back, and the trial court judge then hits all the marks but reaches the same result. Isn't that a possibility here?
I would argue that it's not, Your Honor. I would argue that the only focus here was on the bond between the child and the mother.
So let's say we do send it back, and the trial court judge does what I think the trial court judge could very well do, hit all the marks and still deny. What's the standard of review by the Superior Court from that trial judge's decision at that point in time?
Standard of review would be abuse of discretion, Your Honor.
Yeah.
Let me just, if I could just get back to why this standard is so important. If we say that any bond is enough to prevent termination of parental rights, then what we will have is we will have almost no termination of parental rights in the Commonwealth. Foster children in this Commonwealth who are, at least in Allegheny County, the majority of them are placed in kinship foster homes. In Allegheny County, 63% of the TPR petitions filed in the last 4 years were for children, young children, children ages 5 or under. Those children will not have the ability to achieve permanency.
But wait a minute, why the gloom and doom prediction that this case presents such a dystopian result? I mean, this case, the judge wrote a 1925 opinion, and he talked about the bond in this case, right? I'm not sure I understand why an affirmance here would change the law. I come back to the apparent reality that the change in the law would be saying that you have to have this extreme emotional layer added in. Why is this case such a dramatic, presents us such a dramatic sea change in this area?
Your Honor, for almost 30 years, the appellate courts, certainly the Superior Court, in dozens of cases has applied this extreme emotional consequences standard. Keep in mind, by the way, there's also the necessary and beneficial, which I think is even more firmly rooted in our precedent. That has been what we have looked at. What happened here, we argue, is something short of that. The trial court did not make a determination that the bond was necessary and beneficial. The trial court did not weigh in on the effect of severing that bond other than saying it would have an adverse effect. What we're saying is that it needs to be something more than an adverse effect, because the result will be that any orphans courts across the Commonwealth can be presented with TPR petitions in cases like this with young children who've been in the same home, it's the only home they know. Orphans Court can look at that and say, severing this bond, I think will cause the child some sadness. I'm not going to terminate, and this child is left in limbo. There's nothing that will allow this child to achieve that permanency, that knowledge that this is my home, my forever home. This is the family who I will be with for the rest of my life. That possibility is foreclosed for them.
Counsel.
Yes, Your Honor.
I can't help but read your argument to equate to the fact that the bond doesn't make any difference at all, although the statute tells us to look at the bond. I mean, I can't come to a conclusion other than, regardless of a bond, the permanency for the child is the only thing that matters.
Forgive me, Your Honor, if that's what I have presented to you today, because
Well, tell me why I'm wrong. I mean, because
The bond
where
is
does it fit? Where does the bond fit into an analysis?
The bond is a very important factor. It is one of a host of factors. If the bond is going to be so significant that it trumps everything else, that it allows an orphans court to say, this alone, I don't have to look at anything else. I'm going to deny the petition based on this one factor, the bond. What I'm saying is that it had better be, it needs to be a significant bond that will cause the child to suffer extreme emotional consequences.
You wanted magic words, in other words. This judge wrote a 9 or 10-page opinion. It may not be like Cardozo's Paul Graf. I mean, but he wrote a 9-page opinion, and he talked about the evidence, and he said the child would be adversely affected if I severed this bond on a permanent basis. It seems to me that you want from us a ruling that there are magic words that we're going to insist, and if we don't see those magic words, your permanency mantra will lead to a reversal of all of those cases and an elimination of Troxel versus Granville rights.
Except, there is no magical word bond in the statute. The words in the statute are the developmental, emotional, and what's the other one, physical?
Yes.
Permanence. They're the magic words. And the issue here is not whether we're looking purely at this judicially created bond. The word bond comes from case law, not statute. We read the statute as it is. When we're considering the requirements of the statute, one must look to other factors other than the bond with the parent. They must look at the emotional and developmental issues. And that would take into consideration the length of permanency with the child with a foster parent. That's where your argument is that this could disrupt the child welfare system should this court rule that bonding, not within the statute, judicially created, now trumps the statute. I think that would be a problem of separation of powers.
I agree with you, Justice Doherty. Justice Wecht, I'm not looking for magic language. I'm giving you the language that courts in this Commonwealth have used for 30 years. If we change the language, that's fine. I would ask the court, though, to take into consideration why it is important to consider the effect of the bond.
Well, just a minute. We have an abuse of discretion standard here, correct?
That's correct.
And I don't see anything that tells me, other than perhaps not using magic words, anything that tells me that Judge Regan did not conduct a proper proceeding and consider all the elements and exercised proper discretion. Moreover, setting aside the bigger issues of what might happen if we allow his opinion to stand, allow the Superior Court opinion to stand, in this particular case, there's nothing to prevent the termination of parental rights action of rising again if mother does not meet the expectations that the lower court wants her to meet, that she's expected to meet as a parent. If she goes off the rails, this is not over. There can be a new termination of parental rights petition, could there not?
There could, Your Honor. But before I get to that, we're not saying this was an abuse of discretion. We're saying that it was an error of law for Judge Regan not to apply the standard in a way that our courts have said. Judge Regan did not find that this was a necessary and beneficial bond. He did not find that severing this bond would
He
cause the child.
misstated or misapplied the law in your view.
He didn't even consider these other factors.
Well, that was my point, so there's a list of factors, there's a list of weighing factors that a court has to apply in this circumstance. That's your view, right? Of which
There are a number. There
of
are
which
host-
parental bond is one, permanency is another, and there's other factors, right?
Yes, Justice Brobson.
In your view, any time a trial court fails in a 1925 opinion to address every one of those factors and weigh them against each other, that is reversible error.
I'm not extending that far. What I'm saying is that in this case, it didn't happen.
Because, so if you're not saying that the trial court 1925 doesn't have to talk about every single factor, then as I understand your argument is, and again, we're only looking at the 1925 opinion. To the Chief Justice's point, we don't know what animated the judge's decision other than what we have in the 1925. Your point is the 1925 only talks about bond of the parent. It doesn't talk about any other factors. And you're saying as a matter of law, the failure to talk about any of the other factors other than the bond with the parent was legal error.
That's the only way that we know to analyze how the trial court reached its decision, Your Honor.
So then you are asking us to set forth factors, and much as we do in custody cases, say to the court, you have to address each and every one of these factors when you write your opinion.
I'm not saying that there needs to be a list like in custody cases. I'm saying that there already exists a whole host of factors, like the child's need for permanence, like the child's attachment. Like, for example, in this case, the court-appointed psychologist found that KT, the child, had her primary attachment was to her foster parent. Her attachment to her mother was ancillary, more like an aunt or a big sister. There are a number of factors that appellate courts have directed orphans courts to consider.
See, here's the problem, though. The orphans court heard this evidence, and the standard that had to be met was clear and convincing evidence that termination would serve the needs and welfare of the child. The bonding, the B factor had to be met with clear and convincing evidence. I read the trial court opinion, and I say he decided there wasn't clear and convincing evidence. I mean, that's the rub in this. It gets down to this case, this judge, this trial, this child, this mother. And a lack of clear and convincing evidence would lead you to the conclusion that the orphans court reached in this case.
Well, except that, Your Honor, the clear and convincing evidence that the court considered was solely related to this bond. And the court did not consider all of these other factors.
You want us to put together the list of factors and say to the orphans court, you have to address each and every one of these factors.
Because you cannot say he did not consider them. You're just saying he did not detail them in his opinion.
I don't think there's a list of factors. I think what counsel's arguing is that an opinion and a 1925B should have, in a 2511 needs and welfare analysis, there has to be some evidence of some developmental, physical, and emotional needs of the child, and that could be shown through such intangibles as love and comfort and stability. And when it's not in a 1925, then it's an error of law. It's not in an opinion, it's an error of law. You're not asking this court to create, again, as we created the word bond, you're not asking us to create magical factors. We're just asking you to apply the law, correct?
That's absolutely correct.
It's pretty straightforward.
Yeah, see, that's the issue. I think that whether the 2511B analysis that the trial judge did here in addressing the bond at length implicitly ignored other aspects required to be addressed or not, and if so, was that an error of law? Or if that analysis was adequately subsumed in his discussion of the bond, because if it was, then if we were to rule in your favor, we'd be contravening our recent jurisprudence when we've repeatedly instructed the Superior Court not to reweigh the evidence, right? The trial judge looked at this evidence. He decided the mother's made progress. I'm going to give her another chance. And we've been instructing the Superior Court, you know, don't reweigh that kind of thing, but here we would be.
Well, except that our point is that it wasn't weighed in the first place. It was just this one, the trial court looked and said, severing this bond will have an adverse effect. We're arguing that adverse effect is the wrong standard. If this court disagrees, what we're arguing is that it should be a standard, the standard should be something like extreme emotional consequences for the reasons that I've explained, because if not, then there won't be terminations. The child welfare system will be disrupted. Children like KT, who are 5, will be left in legal limbo. Chief Justice Todd, you mentioned the fact that CYF could file another termination petition in the future. And yes, they could. But that delays the permanency that KT in this case is entitled to, and the children like her are entitled to. We shouldn't get to termination and have the Orphans Court be permitted to deny, say that, well, there's a bond and I think the child will be sad, and so I'm going to deny this, but let's wait a year or 2 years and see what happens down the road. That perpetuates this impermanent placement that this child has.
But in this case, the child's placement would remain unchanged.
Not necessarily.
That's correct, but the General Assembly, this court, have put an emphasis on permanency, and this child has missed out on permanency, continues to miss out on permanency because of how this 2511B analysis occurred.
And in practical results, despite the fact that this child is bonded with the foster parent, should this court rule the way and continue this fabrication of a bond between this parent and the child? Just for the record, how many years has the child been in placement?
The child is 6 and a half and has been in placement since she was about 9 months old, Your Honor.
And the federal requirement is 15 out of 22 months demands.
That's correct.
So we've kind of tripled that for this parent to develop a lifelong bond.
Well,
and
yeah.
we know, we could all sit up here as armchair psychiatrists and say a child that was beaten by the parent will run to the parent before it will run to the stranger. That's commonsensical. So the issue really becomes one of, what are we looking here? Are we looking to delay permanency? And as a result, if foster parent, the practical real life aspect of this court case is that hypothetically, if parent and now foster parent don't get along or they're angry at the results, children and youth can remove that child from the foster parent despite evidence of the bond and place it in another foster home and create all new trauma, correct?
It's absolutely correct, Your Honor.
And yet, we'll deny that foster parent's relationship with the child for the bond of a parent who hasn't reunited with the child in 5 years. That's the plain evidence of this case.
That's correct.
As long as everybody sees that.
So you want us to ignore everything but permanency?
I'm sorry.
You want us to ignore everything but permanency for the child?
No, that's not it at all. That's
Well,
not
that's what Justice Dougherty is
No.
arguing, and you agree
That's
with
not
him,
the bond. There are so many factors that should be considered.
So many factors.
So back to Justice Brobson's question. Why wouldn't this be a remand to the trial court?
Well, Your Honor, our position is that all of the evidence, all of the information about the factors that should have been weighed in this 2511B analysis are here.
So you want us to weigh the evidence?
It's not that we're asking you to weigh, it's just that it's not a close call case. This is a child who has been in care for almost her entire life with this same family. The expert testimony that the Orphans Court heard clearly, unequivocally stated that the only goal that would meet this child, the only outcome that would meet this child's needs is adoption. The Orphans Court relied on Dr. Rosenblum's testimony in ways that don't really match up with his testimony.
Well, that's your grand slam, to use Justice Brobson's apt term. In the event that you were to get relief in this court, I'd like you to explain to me, again, I guess, how it would be appropriate for the court to send it back with a direction to enter termination, given that we don't know what's gone on in the intervening time between the last time they were in front of Judge Regan. At the very least, wouldn't we have to send it back? And it wouldn't be Judge Regan because he's in the civil division. So it would be a new judge, presumably, who needs to get us at least a snapshot in time of what the heck's going on now. Wasn't that the case?
Your Honor, if you, the important thing for us today is the standard, and is the fact that an orphan's court needs to consider all of these factors, and is the fact that that's not what happened here. I understand your point about what has happened in the intervening time. I understand that that could cause you some pause. And so if you say, yes, the orphan's court erred, this was legal error, they did not weigh the 2511B factors like they should have, they overemphasized the bond without considering the effect of severing that bond, that is the outcome, send it back for the proper 2511B analysis. I think that that would be acceptable. The underlying issue, though, is that we need this court to what we say is reiterate how orphans courts should conduct their 2511B analyses.
Or write their 1925 opinions.
Perhaps, Justice Brobson.
Okay.
All right, let's hear from
Thank you.
CYF.
Good morning, Your Honors. Thank you. So I am going to try to address where we think the Superior Court made and engaged in its own error, both at law and perhaps in an abuse of discretion. So, and I might try to re-answer some of the questions that you presented to my co-counsel. So the Superior Court was very clear, and we agree that the Superior Court articulated the correct standard of review for a termination case. But what we don't believe the Superior Court did is we don't believe the Superior Court applied that standard of review appropriately, and or we don't believe that the Superior Court engaged in the full range of review that it should have. Most specifically, the Superior Court did review the record and place significant emphasis, as it should have, on the trial court's findings. Mother, too, in her brief, puts significant emphasis on the trial court's findings. However, when one takes a deep dive into the actual testimony in this case, one would see that the trial court abused its discretion by taking testimony out of context so that ultimately the trial court's findings are not supported by the record.
Oh, that's a different argument then, because opposing counsel made what I think over the course of the argument distilled to a clear view that what we have here is an error of law. But you're telling us now, and he supported that with the argument that the needs and welfare analysis needs to do more than address the bond. That's what I took away, essentially. Whereas you're now telling us that the trial judge abused his discretion by weighing the evidence incorrectly. Is that different,
No,
or is it the same?
I'm so sorry, Your Honor, but I disagree with that. I don't believe that that is the case, and we are not in any way suggesting that how the trial court weighed the evidence was incorrect, nor are we suggesting that the trial court did not give sufficient credibility to the witnesses. In fact, I think the trial court, and it's very clear in his opinion, found Dr. Rosenblum, who was the primary witness for needs and welfare issues, found Dr. Rosenblum to be incredibly credible. It's all over the opinion, what Dr. Rosenblum said, what Dr. Rosenblum said. So it's very clear the trial court not just found Dr. Rosenblum credible, but also relied heavily on Dr. Rosenblum's testimony. However, and I don't disagree with my co-counsel that there are errors of law here, but there are also abuses of discretion. So this case, I believe, represents both issues. So going back.
Counsel, Justice Donahue?
I lost the train of thought.
Are you suggesting that the Orphans Court was bound by the conclusions drawn by the expert?
No, I agree with some case law provided by Mother, and I think statements also by the the dissent in the Superior Court that no, the trial court is not actually bound by the conclusions of the expert, but you have a trial court that found the expert to be credible, found the expert's testimony to have great weight, and then suddenly ignores whole sections of that same expert's testimony.
You're making a substantial evidence argument.
I'm sorry.
You're making a substantial evidence argument. You're basically saying the trial court's factual findings were not supported by substantial evidence.
Oh, absolutely.
Right.
I am saying
So
that.
that's in addition to or on top of the legal error argument. You're saying, putting aside the legal error, the trial court made erroneous factual findings with a lack of substantial evidence of the record.
Well, I'm not sure how to answer that. There was certainly substantial evidence.
To support the trial court's findings of the bond?
No, in that I think not.
Well, then that's the argument, right? There's no substantial evidence to support the trial court's findings of the bond that, assuming that was not legal error, there's no factual record to support the findings relative to that factor.
I would completely agree with that.
Wait,
And in the important parts of
I
that.
thought you were here to talk about the Superior Court's opinion. And I'm getting confused because opposing counsel offered a legal argument, and you're here talking about substantial evidence, which doesn't seem to be an aliquotter type issue for us. Where are you on this?
All right. So let me go take a step back, because what I believe the Superior Court did not do is the Superior Court accepted what was in the trial court's opinion, but did not go back into the record to determine whether the court's findings were actually supported by the testimony that the trial court was relying on. And I'm arguing and suggesting that the trial court's reliance on statements made are not supported by the transcript in that. And as an example, and I'll get back to how that applies to the Superior Court, but as an example, the trial court relied really heavily in determining whether there was even a bond between mother and child on an assertion that Dr. Rosenblum said the child has an attachment with mother. Yes, facially, that's what is said in the transcript. That statement, that phrase, that clause exists in Dr. Rosenblum's testimony, but it is only a portion. It's a clause. Dr. Rosenblum said child has an attachment with mother, but it's not her primary, but it's only ancillary, but she wouldn't be detrimentally harmed.
I'm sorry to interrupt you again, but once again, this is convincing me from what I read in your brief that you just want us to reweigh evidence that ostensibly the Superior Court weighed, and we've told the Superior Court, don't reweigh what the trial court did. It seems to me you're taking away from your co-counsel's legal argument, which, if there's anything interesting in the case, that seems to me to be the interesting feature here. So why are you taking us into an invitation to weigh this evidentiary record?
Well, I don't think I'm asking the court, I really don't, Your Honor, think that I'm asking for you to change the weight that the trial court gave to the evidence. I do think that, so obviously the Superior Court error was in not acknowledging the trial court's abuse of discretion and the trial court's legal errors. So let me step into that for a moment.
Let me try to help you for a second.
Okay.
One of the issues on appeal, I guess, was one of the issues on appeal that the trial court's factual findings related to the bond with the parent was not supported by substantial evidence. Was that one of the issues in front of the Superior Court?
Yes, it was.
That was one of the statements?
I believe we did allege that, yes, in our Superior Court's argument.
So you're saying that the Superior Court erred in its resolution of that issue because it took what the trial court wrote as the evidence in the opinion, but did not go in the record to determine whether the evidence in fact said that. It's not a weighing issue, it's a, is there any record evidence to support it?
And I sort of go back and forth on that.
And I'm not sure we took this issue. That's what I'm also not sure we took this. I mean, you're going into this, but I'm not sure we took this as an issue on appeal.
You took it on the issue of the legal error, and I do believe that the Superior Court engaged in legal error by not requiring the trial court to apply the appropriate standard. I mean, certainly that did happen.
We didn't take a question of whether there is any evidence in the record on the bond question, on the parental bond question.
Yes, you did not take this on the basis of whether there was, well, you took it on the basis of what was the standard to determine bond. And, if you're reaching...
What was the standard to determine termination of parental rights, not to determine bond?
Well, yeah, it's the standard to terminate parental rights in the course of making a needs and welfare analysis. And the trial court's needs and welfare analysis was in legal error, but it was also based on the trial court's abuse of discretion in how it applied testimony. And again, I am not asking or saying that the weight of the testimony is incorrect or the credibility of the witness is incorrect. One of you honorable justices asked about whether the trial court is required to accept the experts' conclusions and recommendations. And the answer to that is no, the trial court is not. But when the trial court capriciously disregards that evidence, that credible, uncontradicted evidence that impacts this child's emotional needs and welfare, then at the minimum, the trial court should explain why. And in this case, the trial court did not. The Superior Court did look through the record. I am not just suggesting they did not. I don't think that they observed the misapplication by the trial court of testimony to reach its conclusions that were ultimately erroneous. But the trial court's conclusions were erroneous in part because of its misapplication of testimony. The trial court's conclusions were also erroneous because it applied the wrong standard, the wrong law. And the Superior Court, while acknowledging what the legal standard was for assessing the nature and status of bond, as well as the effect of bond, then did not require the trial court to maintain that same legal standard. So that was an error of the trial court. So, of the Superior Court, I mean. So the Superior Court's error, I mean, they looked at the record. That's what they're required to do. They're required to, under their standard, accept the findings of the court if they are supported by the record. And we are asserting that those findings are not supported by the record, and that was part of the Superior Court's error. But then the Superior Court is also supposed to determine if there are any errors at law or other abuses of discretion, and we're arguing that the Superior Court did not expand its review into that area. All the Superior Court did was said, oh, look, and I apologize. What it seems to me that the Superior Court did is said, okay, the trial court says that Dr. Rosenblum said child has an attachment. Look into this transcript, and yes, look, there's this sentence, child has an attachment. But didn't look to see the rest of that sentence, which I believe is an abuse of discretion in not having done that. That is not a question of weighing the evidence. That was just a pure abuse of discretion.
Because the expert said so much more than that in context.
Exactly. Exactly. And so that is part of the trial court's abuse of discretion, taking all that information, that testimony out of context, and that it was legal error for the Superior Court, it was error for the Superior Court to not acknowledge that abuse of discretion by the trial court.
Any other questions for Attorney Kay? All right,
Thank you.
Yes, you did, Your Honor. Thank you. Good morning, Your Honors, and may it please the Court. My name is Matthew Hammermesh of Hingley, Aronchick, Siegel, Pudlin, and Schiller, counsel for Appellee, the mother, in this case. Counsel from Kid's Voice told you that the trial court denied termination here because it found that the child will be sad. That's just not a fair characterization of what the trial court did in this case. The fundamental issue here is whether this court and the Superior Court are going to trust trial courts to make the right decisions in these cases, or instead are the appellate courts going to have to redo the cases based on a cold record. Here, it's true that the trial court, in its opinion, focused on the bond between the parent and child, and also the effect termination would have on that bond. But it's not correct to say that that's the only thing the trial court did. The trial court looked at and weighed evidence on all of the factors the courts have discussed on as relevant to the needs and welfare analysis, including particularly the issue of permanence.
How do you know that?
By reading the trial court's opinion, Your Honor. The trial court refers to evidence that
Counsel, I don't mean to cut you off, but I want you to address this. Page 15 through, what was it, 15 through 18, actually 19, of the judge's opinion, where he gives his explanation for denying a basis of clear and convincing under 2511B. Share with me, or share with us, where he discusses the developmental, physical, or emotional needs and welfare of the child, because when I read his Honor's opinion, it only discussed the 7 or so witnesses who testified as to the bond between mother and child. So share with us, in the opinion, your comment that there was other evidence to Her Honor, because unless I'm misreading, his explanation for denying 2511B is written in page 15 through, and there's nothing other than bond. So where did I miss this?
Your Honor, so I think, subject to my rereading it again, from my recollection, I think you're right. In that particular analysis part of the opinion...
That's the opinion that controls.
Correct. In that, well, if I may, Your Honor, in that part of the opinion, the trial judge didn't discuss anything, I think, other than the parent-child bond and the effect of termination. But in other parts of the opinion, going through the two days of hearings, 10 witnesses who testified, the court did discuss the evidence about permanence. For instance, the fact that the child did refer to the foster mother as mom, that the child has lived with the foster mother since 2017, and the foster mother has been treated as an adoptive resource, and Dr. Rosenblum's testimony about the benefits of a permanent relationship with the foster mother.
We're here for a very singular and discrete legal issue.
Yes.
And that is, did His Honor make an error of law in determining a needs and welfare analysis by exclusively and only writing an opinion with regard to the bond between child and parent? So that's the question. And the question I have for you, is it an error of law for His Honor to have only written an opinion in developing his needs and welfare assessment of the child's bond to discuss only the bond between the parent when the statute specifically and unambiguously reads primary consideration to the developmental, physical, and emotional needs of the child? So I think that's a pretty straightforward question. So is it yes or no?
Respectfully, Your Honor, I disagree that it's a legal error for the trial court to issue an opinion that focuses on one aspect of the needs and welfare analysis. because while that may be the primary issue the trial court focused on, it's clear from the trial court's discussion of the evidence that the trial court considered all of the issues relevant under the needs and welfare analysis, even if it didn't walk through them in a checklist format in the analysis part of its opinion.
Follow up on that, because I think Justice Doherty's put his finger on what's interesting in the case legally. It's the issue, I think, that Kid's Voice raised. And by the way, thank you for taking this appointment.
Oh, it's a pleasure, Your Honor.
What do you think this court should say, whether this is an affirmance or reversal? What do you think this court should say the rule of law is for trial courts when they make a decision under 2511B? In other words, are you saying that the rule is that an adjudication on bond fairly subsumes the developmental, physical, and emotional needs and welfare, or would you say that there has to be some articulation of that in the opinion? I think that seems to me, at least, to be the interesting legal issue in this case at this point.
Yes, Your Honor. So I think in terms of articulating a standard, first of all, Section 2511B has a standard in it. And I'm probably going to misquote it, but the physical, emotional, and developmental needs and welfare of the child. So that's the first part of it. And then beyond that, I think this court has already articulated what that means, and I apologize, I don't have the quote immediately in front of me, but love and affection, stability, things like that. But it also said that utmost attention must be paid to the relationship between the child and the parent and the impact of termination on that relationship.
Well, we've said, right, I mean, presumably it can't only be a bond analysis, right? Because we've said that it's not absolutely required to have a bond analysis, right?
Well, I think EM, says that there does have to be some analysis of the parental-child bond.
Okay.
But
have we said that a psychologist is required to evaluate the bond? I thought we did not.
I don't believe so, Your Honor, no.
Sorry, go ahead.
That's okay. But I think, Your Honor, a critical issue is that under 2511B, the statute calls for a holistic, individualized analysis of each case. So all I think the court can do in terms of setting a standard is what it's already done, which is cite the statute and lay out factors courts should consider: love, stability, et cetera, the parent-child bond. Permanence is a factor courts should consider. I think the question that the appellants have raised is, in effect, does a trial court have to go through a checklist that it's considered each of these factors? And then they go beyond that and say, particularly in the context of considering the parent-child bond, it's not just that a court should consider the parent-child bond and the effect termination of parental rights would have on that bond, but specifically the trial court can only consider two things: whether that parent-child bond is necessary and beneficial, and then second of all, whether terminating the parent-child bond would cause the child to suffer extreme emotional consequences. And those are tests that simply have no basis in this court's precedent, and I would submit that the court should not adopt them. In addition, such a test, extreme emotional consequences, would effectively shift the burden onto the parent to show that extreme emotional consequences would result from termination, which is inconsistent with both the statute at issue and also the constitutional guarantee of due process. In addition, Your Honor, as I said before, this is a holistic process, an individualized process for reviewing the relationship between the parent, reviewing whether termination is appropriate, and limiting it in the way that appellants propose to these specific considerations in terms of the parent-child bond, I would submit is a one-size-fits-all limitation of what courts are supposed to do in what's supposed to be an individualized process and would be detrimental to the very children who are at issue in these cases. Yes, Your Honor.
In evaluation of this bond and this list of factors, if a child looks to the parent and looks forward to the parent, their supervised visits, because let's hypothetically say, as this case indicated, the mother is somewhat juvenile herself and has no parental responsibility, but likes to play like a toddler. And as a result, experts see this as a bond.
Mm-hmm.
Are we considering their childlike relationship to be sufficient evidence for a parental bond? Because if I'm not correct, if we're looking at the factors, your record indicates that the mother had a childlike relationship, unlike the foster mother. But you're asking us to maintain this parent-child relationship based upon the factual evidence in this case that mother acts like a child or a juvenile. I believe that was the word.
Right.
So tell me, how are we supposed to give credence to this bond for an individual who's childlike when we're looking for a parental bond, which she has failed to provide in 6 years the child's been in care?
Well, respectfully, Your Honor, I think, and
Can you
this
answer
is...
my question? Just
Yes, Your Honor. So I think the question, it's not for this court to give credence to that nature of that bond or not. That's the trial court's job. The trial court is supposed to make...
Well, I think we're not making credibility calls. We're here to analyze. I'm asking you in your analysis of your factors, are we to consider that the court indicated that the parental parent, mother, was juvenile-like, or the evidence presented was juvenile in her playtime with the child, and the child looked forward to that?
Right.
And that is the establishment of the bond for which you're asking us to preserve.
Well, two things, Your Honor. First of all, I think that the trial court found that not just that there was a bond, but that terminating that bond would be detrimental to the child, would have an adverse effect on the child. That's the trial court's discretionary determination, and I would submit that under this court's standard of review, the court, that could not be overturned based on the evidence. In addition, respectfully, Your Honor, I don't think that was not quite how I took the psychologist's testimony. What I understood him to be saying was that the child, primarily because the parent has limited, well, she's not as mature as she could be, yes, but primarily because she has limited contact with the child, her interactions with the child focused on her appearance, watching videos, things like that. And to be clear, Your Honor, we're not, nobody is here suggesting today that the child should be returned to the mother now or at some specific point in the future. And I think, Justice Todd, you said this before, that OCYF could come back in the future and say now termination is appropriate, and the trial court could well determine at that point that it is.
And if we say that future, what could happen, the child could be removed tomorrow by CYD from the loving foster parent if it so chooses, should we follow your agreement, correct?
Well, Your Honor, so I think...
The answer is yes or no, sir. Is it possible?
In theory, yes, Your Honor, and I think that brings up an issue that was emphasized in, I believe it was the CYF's brief, which is the issue of foster care drift, which just simply isn't an issue in this case. This is a child who has been with one parent, foster parent, for 5 years. There's no suggestion, and OCYF, who is here arguing for termination, I'm fairly confident is not going to come in and remove the child from the foster parent that they're trying to.
But what you're asking this court to do is to maintain a child in a foster home as opposed to a loving, permanent home because they can file a petition to terminate down the line when the request would be to terminate the petition and file an open adoption so that the child and mother could continue this juvenile childlike relationship. Is that also not an alternative?
Well, Your Honor, what I'm asking the court to do is to affirm the trial court's decision that it's not appropriate in this instance.
Which would delay permanency with this child.
That's true.
And continue the child in foster care.
That's true.
Now, following your logic, how does that increase, or how are we given the child primary consideration to the child's security and safety by telling the child, baby, mommy's not going to adopt you, you're just going to stay this way. So you can play with, does he call, I don't even know, I don't think she calls the mother
I think
mom.
she calls her mom also.
She calls her mom as well?
Yes.
That's what you're asking this. I just think sometimes when we sit up here and we make rules, we fail to see how they're actually applied in everyday life.
Absolutely
And what
true.
I'm trying to show is this is what's happening. You're asking us to maintain a child in a foster care agency, in a foster home, where this home wants to adopt this child. And there's an adoption process called open adoption that they can still see the child, yes?
Yes, Your Honor, I believe so.
Okay.
But Your Honor, respectfully, I think it's the trial court's determination. And the trial court here listened to the evidence, listened to the psychologist, and may have emphasized certain parts of the psychologist's testimony and not emphasized other parts of it that the appellants would have preferred to testify, but concluded that it was not detrimental, that it was beneficial for the child to maintain the relationship.
He said that in the opinion, maybe we would not be here today, but as I read the record, very similar to my colleague, Justice Doherty, the trial court says, there's a bond, termination's off. He doesn't say whether it's a good bond, he doesn't say whether it's a bad bond. He doesn't put it in perspective with any other factor. He doesn't talk about permanency, he doesn't talk about the welfare of the child, he doesn't talk about the needs of child. He just says there's a bond and that trumps everything. And in my view, you have to have a factored analysis according to the statute where you look at the bond and you assess whether the bond is such that it outweighs these other factors. And there's just nothing in this record whatsoever in the trial court opinion that talks about any of that.
Well, Your Honor, I think, first of all, the judge said there's an adverse effect would be an adverse effect from terminating the bond. And at least implicitly, well, Your Honor, I think this court's decision in TSM provides a good illustration of that. On some level, the point of the decision in TSM was that, yes, there can be a bond, but it can be a detrimental bond, which there's a benefit from terminating. That was the right decision in that case. This is not that case. That was a case where there was a parent who was abusive to multiple children in different ways over many years, and the trial court's conclusion, or this court's point was that termination of that relationship, that was not a relationship that was worth preserving. Yes, Your Honor, I understand that. But I think if you look back at the psychologist's opinion here, what he said, his main concern was that, if you read his testimony, I believe, was that he recommended termination of the parental rights in order to ensure the relationship with the foster mother. Nobody here is arguing that the relationship with the foster mother should end. OCYF, who's here arguing against the trial court's decision, Your Honor, respectfully, I'd have to look back at whether he's talking about adoption, but my recollection was his concern was about being in the foster home or not. I understand, but the fact that the trial court denied termination doesn't end that relationship with the foster mother. Respectfully, it's been working for 5 years, and pushing it down the road does not mean it's going to last for another 13. OCYF can come back and ask for termination again. And I think another critical factor here is, if you look at, there were 3 reports by the psychologist in the record, and if you look at them, and I think this was part of the trial court's decision, there's been a clear improvement in mother's situation and approach over the years, which I think is part of why the trial court denied termination.
Counsel?
Yes, Your Honor.
You've been really, you should be complimented for taking on this case and
Thank you.
spending the time analyzing it. And from that perspective, I think our standard of review, if I'm correct, is whether or not there is anything in the record that supports the trial court's opinion. Am I correct?
Correct.
Or is there a different standard here?
I believe that's right.
Okay, and if you could just address that issue. Is there evidence in this record that supports the trial court's decision in this case?
Sure. The trial court heard evidence from 10 witnesses over 2 days, observed those witnesses at that hearing, observed the family at that hearing, observed the family at prior hearings, and asked his own questions. I think I've already discussed our view about the psychologist's testimony. In addition, the trial judge heard testimony about the benefits of permanence, and I think at least implicitly weighed that evidence. There was a lot of evidence, I think, that mostly goes to the 2511A factors, which weren't disputed. But I would submit, Your Honor, that all that evidence supports. The trial court could have reached a different decision, but it's sufficient to support the trial court's decision here. So I wouldn't say it's negated, Your Honor. I think the question is how the trial court weighed it, and I think it's at least implicit in the trial court's decision that he weighed the bond and the effective termination over. Pardon me? Correct. I don't think there was here.
Now, so one more question from your perspective as someone who has reviewed this from a really analytical perspective. I see a dilemma because we have consistently and recently chastised the Superior Court for reweighing evidence. Short of having a trial court in this instance address specifically each and every factor that my colleagues have raised today, are we always going to be faced with a situation where we're reweighing the evidence?
Well, Your Honor, respectfully, I don't think there's a dilemma here because the Superior Court in this case did precisely what you've been telling it to do for
Correct.
Years and years and years. And imposing the sort of standard, both in terms of the standard the trial court should apply and that the appellate courts should apply in reviewing those decisions that the appellants propose would greatly extend the process, delaying resolution of these cases, which I would submit is greatly to the detriment of the very children who are supposed to be served by this process.
But how is that the case? If and you know, we take cases for the future also, but if we say to orphans courts, when you are writing your opinions in these cases as to the B factor, you need to address the following factors in your analysis.
Right.
What's the downside of doing that?
Because that will require the courts to spend more time. So for instance, in this case, I don't have the timing exactly in front of me, but the trial court, there was a hearing, I think the second hearing was in October. I think the trial court's order was issued within a few days or a few weeks of that, and then the opinion wasn't issued until the appeal was filed some months later. Under the regime you're talking about, the trial court, I think before it could issue an order, would have to go through and say, here is what I'm finding as part of that order on each of these factors, which would delay resolution of these cases.
But if we don't do that, then we get a case like this where the trial court writes an opinion supporting his decision on this issue, and the argument is, well, we look at his opinion and he obviously didn't consider X, Y, and Z. But we don't really know that because, as you said, the procedural and factual history that he sets forth indicates his consideration of all of that evidence.
Right. I think two things, Your Honor. One, that's exactly right. You have to look at the evidence that the court considered as reflected in the opinion, which is what happened here. And then I think, frankly, Your Honor, and this is just part of the standard of review, this court and the Superior Court have to trust trial courts when they're deciding these cases, because they're the primary ones who are dealing with these sorts of issues on the ground. Unless you have anything further?
Thank you, Mr.
Thank you, Your Honor.
And again, on behalf of the court, we appreciate your taking this appointment pro bono.
It's my pleasure. Thank you.
Cases left. I think the court is going to take a lunch break, and then we'll be more alert and friendly this afternoon. There are the two cases, Franczyk versus Home Depot and Yunt versus PA Lawyers Fund. Please be back by 1 o'clock, and we'll begin the afternoon session. Thank you. In this case, an employee was injured at work when a customer's dog bit her. The issue before us is whether the exclusivity provision of Section 481 of the Workers' Compensation Act precludes the employee from filing a tort action against her employer for negligently investigating her work injury, the dog bite, and impeding her ability to seek relief against the third-party tortfeasor who caused the work injury, the dog owner. If that is correct, please proceed.
Thank you, Your Honor. Good afternoon, and may it please the Court. My name is Grant Stringham. I'm an attorney for the appellants, Philip Rogers, Thomas Mason, who are employees of Home Depot, and co-employees of the appellee, Lindsay Franczyk. As aptly stated, the question before this Court is whether an employee who has had an accepted work-related injury can sue her employer in tort for an alleged failure to properly investigate a workers' compensation injury, thereby allegedly impeding her ability to proceed on a claim against the third-party tortfeasor. Appellants respectfully submit the claims against them are barred by the express language of the Pennsylvania Workers' Compensation Act, which provides the sole and exclusive remedy for employees against their employer for personal injuries suffered during the course and scope of their employment. Further, permitting such claims would be contrary to the legislative intent, would open up the floodgates to artfully pled litigation by employees against their employers for negligent post-tort investigation, would impose onerous, unwarranted, and limitless investigatory burdens upon employers across the Commonwealth, and that upholding this ruling would in turn also be contrary to the Superior Court's holding in Kolick and the cases that it cited. The questions involved, as already stated, are whether this is permitted by the Act and whether the Superior Court in turn essentially violated its own precedent. First, as this Court emphasized in Poser v. Newman, there's a historical quid pro quo, which was the intent of the General Assembly in enacting the Workers' Compensation Act. In exchange for liability to an extent or accepted damages without fault, employers in exchange were provided immunity against all lawsuits by employees for any work-related injury as defined by Section 301C of the Act. Now, as a result of that historical quid pro quo, a tort action by an employee against her employer for any work-related injury is barred. Now, this exclusivity of the Act is jurisdictional. As the Court held in LaFleur, the Act deprives the Common Pleas Court of jurisdiction of common law actions in tort for negligence against employers, and this is a non-affirmative defense. Therefore, the exclusivity of the Act is near universal. It bars tort lawsuits against employers for both negligent and intentional acts of employers that result in workplace injuries to their employees. Here, we have an accepted workplace injury. There is no contesting that. Whether you describe it as a dog bite for the damages or that the damages are simply the damages related to an improper investigation, they're all bound and by the Workers' Compensation Act, as they all fall within the ambit of the Workers' Compensation Act. Now, this court has held many times that the legislator made clear that the Act is to be a complete substitute for, not a supplement to, common law tort action. There are cases that use the word obliteration when referring to common law cases when contrasted with the Workers' Compensation Act. There are, of course, limited, very limited exclusions to the Act, which, depending on the reading, are not even exceptions, but for cases like Martin, they actually don't define the damages as being a workers' compensation injury. And
let's identify the exclusions to the exclusivity provision so we're all on the same page.
There are exclusions to the Act for, say, personal animus, third-party attack, and the reason for that, the reason the General Assembly defined it as such, and the case law extensively has analyzed it, is that those are not workers' compensation injuries under the Act. And that's how it's defined because there's certain acts that clearly aren't something that you're being injured in as a result of your employment and furthering your employer's business.
Kind of sounds like a dog bite.
Well, Your Honor, actually, the dog bite here is exactly the type of thing that an employer, for instance, would not be responsible for. In fact, when the General Assembly was discussing these types of things, this is the exact type of tort in which an employer would otherwise not be responsible, but for the act requiring them to pick up this without their fault and paying those compensation benefits which were paid.
But here we have that option that the victim, the employee, could have sued a third party, but was prevented from doing so by the employer's action in not allowing her, actually preventing her from ascertaining information to investigate the claim.
Well, again, the question of fact, which is what we have before us right now, is you're getting into whether she actually was precluded or not. Obviously, that's an issue that's hotly contested, but that type of claim still is related to a workers' compensation injury. She was compensated for said workers' compensation injury. Therefore, you cannot maintain it.
Why could you not be stopped from, you failed, you are raising the exclusivity provision, yet your organization blocked the opportunity for the inquiry as to the third-party information, thus the third-party lawsuit. Whether you agree or not that there's a prevention or a disputed factual basis for the prevention of this information, our record reveals that they were not precluded and they were told they were not allowed to speak, nor did Home Depot speak to the witnesses. So why should you not be stopped?
And just briefly, I'd note that the appellee testified that she didn't ask the alleged tortfeasor what her name was. She didn't ask for her information at any point. She didn't ask the first 3 employees that she spoke to ask the tortfeasor what her information was. But let's assume that going down that road, that the court were so inclined as to create right now a claim, which is what essentially they're asking us to do, a post-tort claim that has damages that are precluded by the act and as expressly stated. Where does that road lead? What is the standard of the underlying tort that appellee is attempting to create?
Before you get to where the road leads, let's just look at the beginning of the road here. If the employer had dangerous machinery in its shop and the employee is injured by virtue of a product defect on one of the machines, she could collect workers' comp, correct?
Yes.
And she could potentially sue the manufacturer of that machine.
Yes, Your Honor.
How does this differ from that?
It is not any different. And if the employer had lost the information for the manufacturer of that machine, would we still be here discussing whether in absentia the employer could be sued based on who knows what standard? Or are we assuming liability on the employer for the third party's actions that may or may not have been tortious in the first place, and then allowing this to proceed for damages that are precluded expressly by the Workers' Compensation Act?
Well, but in order for the cases to be analogous, the employer in the machine case would have had to allegedly prevent the employee from finding out who manufactured the machine, right?
Yes, and in that scenario, the Workers' Compensation Act would still hold, and the case law would still hold same. In fact, this court has held in similar cases. In Cooney, for instance, when they were analyzing whether an insurance carrier who had the same protections as the employer, and they supposedly interfered and impeded the employee's ability to pursue a third-party claim, if they could sue the insurance carrier. And this court in Cooney held, no, they can't. And it's for the exact same reason that employee couldn't sue the employer. They stood in the feet of the employer for the purposes of the act and were protected by the act.
Counsel, can I go back to your first statement that there's some conflict on the record or as to the evidence as to the collection of information? At a minimum, doesn't that appear to provide at least a genuine question as to whether the failure to obtain that information rises to the level of negligence such that summary judgment is inappropriate?
Respectfully, absolutely not. And that's because in order to create any tort at all in common law, what we need for that tort is to not be expressly barred by the legislature, precluded, if you will. Now, the legislature has precluded claims for workers' compensation injuries. This is a workers' compensation injury. Everyone accepts that. You cannot move past that because it's barred. Otherwise, we have no separation of powers. In fact, if we go to Poiser case, this court expressly...
Saying that as if there are no exceptions, and we know there are some exceptions, and we know that, that an employee can sue a third party for negligence or product liability.
This is not even remotely within the realm of one of those exceptions. The exception that we're discussing here is really just Martin, because the other ones are defined by the Act, personal animus, third-party attack. That's not an exception, that's a definitive, this isn't a workers' compensation injury. It's not a, this is a workers' comp, but we're accepting it from the Act. Now in Martin, what we had was intentional fraud that this court said it was not the workers' compensation injury that they were allowing to be part of the damages. It was expressly stated that it was an exacerbation through fraud of the workers' comp injury. And I would expressly like this court to review the concurring opinion by Zappala in the Martin case, which clarified that, at least in his opinion, this court was not granting the ability to sue for damages for the workers' compensation injury. And he said that's expressly why he concurred with the opinion, is that what they were actually looking for, and I can take you to the language, is that what was covered by the Act, the actual exposure, is not the damage that they were looking for, and that it was actually the exacerbation through fraud of physical injury directly caused.
Don't we have similarly an aggravation of an injury here, where the employee claims she was injured by a dog bite, and then that injury was aggravated by her not being able to seek compensation from the dog owner?
Respectfully, no. What we have here is post-tort conduct that in no way exacerbated her physical injury. It's a physical injury, which is a very important distinction here, because what Apelli is looking for on damages, and actually before I get to that, I think we have to go down the road of where this leads. This is a tort...
You didn't answer that question.
Oh, sorry. I'm sorry, Your Honor. What was...
Finish the aggravation of an injury answer.
Yes, this is not the aggravation of any physical injury whatsoever. There is nothing that can be said about the investigation by co-employees, which we'll get to later, and that tort in and of itself is precluded, that in any way exacerbated her physical injury. It did nothing of the sort. What we have here is an attempted standalone claim for failure to investigate that simply doesn't exist, and it can't. It can't expressly because the Act says it can't. And whether we find it to be an entertaining question or not, and that's where I'd go to for the Poiser case, is that is for the General Assembly to decide, not this court. And this court has held many times over that that is the case. And again, I don't see any way that you can even describe what was done post-tort as an exacerbation. And beyond that, there's no fraud. That had an independent active tort that we know existed, and they applied it in such a way as to not even really define the injury as the workers' comp injury. The injury was the aggravation.
Well, we don't have to recognize, I mean, to resolve this issue, we don't have to decide whether or not a cause of action exists for negligent failure to preserve evidence for a third-party claim or negligence in impeding a claimant from potentially pursuing a third-party claim. The real question in front of us, we can assume, let's just assume for our purposes that such a tort exists. Can you recover in that tort from the employer is that recovery a quote injury, close quote, in the course and scope of employment, and does it therefore fall within the exclusivity clause? That's really all this is.
It's a good question. The reason that, well, for the actual application, there are a bunch of other issues, but let's assume, as you have, that we have a tort claim for this. The damages are inextricably intertwined with the actual workers' compensation injury. And beyond that, the tortious conduct was done by employees failing to investigate. Employees.
Well, but you went to damages. The definition of injury doesn't refer to damages.
The injury in and of itself is the physical, and that's what they're claiming. They want
an injury to an employee arising in the course and scope of employment and related thereto. That's the definition of an injury in the statute.
You're right, and the post-tort conduct would also be described by that exact language, because the post-tort conduct is that of two fellow employees who allegedly negligently investigated. And we have plenty of case law, the Kolick case and the Gardner case, that says any reasonable reading of this act says that any negligence at all done in the course of scope of employment that injures another employee who is also in the course of scope of their employment is barred by the act. So even if we go that far, What we have is a negligence claim against 2 employees, by an employee, all of whom were acting within the course and scope of their employment. Therefore, even if we wanted to assume that these damages weren't initially the workers' comp damages, it's still barred because the acts of the employees is covered. And because of that, we can't get to a place where we even analyze it. And obviously, the rabbit hole this takes us down is extensive, because what would we be apply as a standard for damages? What would we apply as a standard for the negligence? What do we need someone to do investigatory-wise in order to meet that standard? And at that point, if we allowed for such a tort, it would be near malpractice for any plaintiff's attorney in this Commonwealth to not sue the employer for any portion of an investigation that they feel doesn't meet their threshold, and they don't know that pre-suit. They would have to sue the employer. They would have to go down that road to see if there's a single piece of evidence that the plaintiff says, you know what, that tortfeasor admitted to me right there that it was his fault, and they didn't write that down. They didn't write that admission down. This is the employer's fault, and now I'm going to sue the employer. We're talking about hundreds of millions.
That's far afield from the facts of this case. I mean, I don't see this case as imposing a duty to investigate on the part of an employer. I mean, at its base, as I understand the facts of this case, the employer essentially segregated the employee from the tortfeasor, did not maintain any information after, discussing the dog bite with the third-party tortfeasor, didn't accept the information from a witness who offered it as to her name and identity and contact information. This isn't a duty to investigate. This was a failure to preserve information while at the same time precluding the employee from gathering the information on his or her own. It's different than, there's no duty to investigate here. I mean, if the employer just let these people leave, we wouldn't be here. This was, employer can't talk to the tortfeasor, employer does, and then just discharges them without taking any action.
And respectfully, the only evidence that supports that is by one person, the plaintiff. Actually, all of the testimony to the contrary says that they went through the store, they asked multiple people with dogs, is your dog involved in all these things?
That's a question of fact.
You're right,
and summary judgment.
And I appreciate the question because it brings me back to the point of the floodgates. If we allow these types of claims, any artfully pled pleading will permit this to go to a jury on the facts when the damages are precluded by the act. The acts are precluded.
We aren't on the pleadings. This is summary judgment. Is it not?
It was summary judgment, yes.
Yeah, this isn't a judgment on the pleadings or anything of that nature. I mean, this is a full-fledged discovery had taken place, facts had been developed, get to the summary judgment issue, goes to a jury. I mean, how is that opening floodgates?
Well, at that point, then, what you're asking is for every employer to litigate every single workers' compensation case where a potential third party may have been a tortfeasor up through the very end to summary judgment. And then if it's what you're really positing is that now this is an issue of fact, which means that we can't even do that. Now we have to go to a trial. A trial on what? To determine the damages?
We knew there was a tortfeasor here. You're expanding the scope of this issue that we have before us far beyond that which actually exists. There was a known tortfeasor here. There was a dog owner who had the dog in the store that bit the employee. I mean, this isn't, maybe there was a dog running loose in the store and somebody should have tracked down who owned it. That's not what we have here. I mean, if we could just focus on what we precisely have before us, was the conduct on the part of the employer something that precluded the employee from pursuing the third-party remedy? And if so, is that actionable conduct?
No, and first of all, we don't know if there's a tortfeasor because we don't know whether this dog had a predisposition to aggression. We don't know if the employee is the reason the dog bit her. We don't know if there's a tortfeasor. We know that she says that she believes another dog bit her, which still doesn't meet the standard of a tortfeasor because we don't have that other person. She also could have asked that person what their name was. Beyond that, this person could have lied to Home Depot. Is Home Depot under a standard where they need to arrest this person, call the cops? How do we know that the person's going to even give us the correct name? There is no way to make this standard equitable.
Why does Home Depot and basically every other business file incident reports, prepare incident reports when there's an incident of injury in the store?
Well, we do that.
If people are going to lie to them anyway, why would they even do that?
Sometimes they do. And to hold Home Depot to a standard that says you're responsible if they lie to you. You're responsible if at any...
No, that's not my question. You said, why would Home Depot want to gather this information? Because people may lie to it. Well, I'm sure Home Depot, in many cases, prepares an incident report, as most businesses do, when someone is injured in their store, in their business.
They do it for many reasons, for workers' compensation reasons, just for any purpose whatsoever. And if we're really...
They did not do it here.
They did, well, I mean, they did try to collect as much information as they could, and they weren't able to locate the actual the alleged tortfeasor in the store, at least according to the managers. They tried, and they couldn't find anyone who said that their dog was involved with it. They asked multiple people with dogs, was your dog involved with this?
But that's contrary to the facts alleged by the employee.
Yes.
So we have that issue of facts, certainly, which is a concern with a summary judgment.
But you got, this was certified, right? This was a certified interlocutory question.
Yes.
Right? I mean, so we only would accept that if there was a legal question that has to be resolved, not a factual question that has to be resolved. So the legal question, and I keep going back to it, is the statute. Let's assume this cause of action even exists. Again, I'm doubtful that it does. And I look at this not from the perspective of your client of Home Depot. I'm looking from the perspective of a small employer on the corner who is subject to the workers' compensation law and whatever duties we're saying that may or may not arise. But let's just stick with the statute for a second, and let's say this is all true, and let's say these employees injured the claimant here by not doing something or by doing something. They were all acting within the course and scope of their employment when all of this happened. Why does it matter what the cause of action is?
It doesn't. It's precluded. I agree that it doesn't matter what the cause of action is if it's based in a personal injury and involves negligence by co-employees against another employee.
If, for example, one of these employees, while driving home, saw the coworker and ran into them, knocking the claimant off the road and causing injury, that wouldn't be a workers' compensation claim because they weren't acting within the course and scope of employment. But here there's no dispute. They were all acting within the course and scope of employment at the time of either the dog bite or the alleged impeding of investigation into who committed the dog bite.
That is correct, and that is why this is ultimately precluded no matter what, based on the act. And moving past that, if I'm trying to go down obviously these hypotheticals to point out how ridiculous it gets.
I don't think what I'm getting the sense of is I don't think going down the road of woe is going to help you.
Thank you, Your Honor. I appreciate that. As I've already stated, I think this is expressly barred, and I don't think it matters how we look at it. I think that this falls within the express wording of the act, the intent of the act, and the reason for the barter between employers and employees in creating the Workers' Compensation Act, so somebody like Aplt can still get workers' compensation benefits, still get wage loss, despite the fact that my client might argue this is not their fault at all and it's not their liability. They still pay for that, and they do that because of this barter, and part of that is the protection of immunity.
Are you aware of the case Minto versus J.B. Hunt Transport? It's a
I am.
Superior Court case from 2009. Can you tell me how your case is different than that one?
Thank you, Your Honor.
There, the Superior Court found that it was not exclusive.
Yes, and before I moved on to Kolek, I really did want to address Dittman. Dittman is in... Minto?
Him and the company lost parts of the vehicle, and so the employee sued the company because he couldn't use the vehicle in a third-party product liability suit.
Your Honor, I'm sorry I did not prepare a brief on that case, as I don't believe it was a part of Apelli's arguments, and I misheard you. I thought you were referring to Dittman, which is relied on in Apelli's brief. Although I would like to address that if you'll entertain me. The Dittman decision is heavily relied on by both the Superior Court and appellee in this case. And, quite simply, it is completely inapplicable to this in any manner whatsoever. It didn't involve a physical injury. It didn't involve a physical workers' compensation injury. The court in Dittman didn't even mention the Workers' Compensation Act or analyze it in any way, shape, or form. And beyond that, appellee's brief misstates this court in saying that they applied the Aplts 5 factors test, which this court expressly did not. They said that what was before them was a long-standing issue with protecting privacy and personal information for employees that you require them to give. That the standard in that is completely irrelevant to this case. And beyond that, if you wanted to go to an Aplts 5 factor test to create a new tort, as we discussed before, the only realm in which common law tort exists is that which is not already precluded by the General Assembly. And here we have a claim that is already precluded. So you cannot get to a point where you create a new tort to then try to create an exception to the act, because the area is precluded. The trial court lacked jurisdiction. It was divested of same, as this court has noted many times, because this injury is clearly work-related. Yes, and the Collick case, which I believe we've already kind of addressed, has to do with an employee injuring another employee, and when that happens, when all of them are within the core scope of their employment, it is in fact precluded. Moreover, I know there was a waiver discussion in the appellee's brief. Jurisdiction, which is what we're discussing, is non-waivable, plus the Workers' Compensation Act is brought up at every stage in the litigation, as is noted in my reply brief. I would just like to leave the court with a quote from the Porzer case, which succinctly stated that although the employee's argument is an interesting one, but it is one that must be resolved by the General Assembly, not this court. What appellee is asking us to do is to engraft upon the act an exception the legislature did not see fit to put there. That is exactly what we're dealing with in this case, and I appreciate the court's time today.
Thank you.
May it please the court, Jason Plakosh on behalf of the appellee, Lindsay Franczyk. Hitting on the points, first with Justice Daugherty, as Justice Daugherty mentioned when he was questioning Mr. Stringham. The issue is 481B. I know you'd mentioned, Chief Justice Todd, about whether this was an aggravation of an injury. What this is, and none of the cases cited by appellant deal with this type of situation, but it is a problem, it's out there, and it could reoccur. What happens when an employee is deprived of a statutory right, which is the right under 481B? Coming from that statutory right, consonant with it are common law rights. Now, we know 481A strictly limits what an employee can sue for when they're injured on the premises, but here we're talking about an actual situation where there was a deprivation of that right, hitting upon Justice Donahue's questioning, just like in the Dittman case, where there was a failure to properly preserve the integrity and the safety and the privacy and confidentiality of that information.
The Dittman counsel has nothing at all to do with comp. It had to do with internet access to data at UPMC. What's the connection where there's no workers' comp exclusivity issue?
The connection's interesting, Justice Electa, because the argument can be made. There's no published appellate case opinion that deals with this type of situation. We know what the exceptions are to the workers' comp statute, but if you look at Dittman, and the court said, and I quote, "Like any other cause of action of common law, negligence evolves through either directly applicable decisional law or by analogy," which in this situation we're looking at analogy, meaning that a defendant is not categorically exempt from liability simply because appellate decisional law has not specifically addressed a theory of liability in a particular context. Now, a situation like this could very easily escape appellate review if an employer wanted to settle it, wanted to make it go away quietly, and the plaintiff says, okay, I'll take a little bit of money and I'll go away. But this is very different in Cooney. In the Cooney situation, you had one coworker physically injuring another coworker. Speaking to Justice Brobson's point, the statute, in terms of how it defines injury, requires a physical injury. Yes, everybody was acting within the scope of their employment. They were all inside the Ohio Township Home Depot store. The manager, the assistant manager, my client was an employee. But the physical injury was not at issue. It's what happened after the fact. Now, Rogers and Mason were acting after the fact in their capacity as managers. There's some factual dispute about whether they identified the right person. My client testifies yes. I pointed them out. There's some dispute between Rogers' deposition testimony and Mason's deposition testimony about whether it had been helpful to bring Lindsay Franczyk to the front of the store, or whether she was supposed to stay where she was told to stay. But this is not about the physical injury. This is about what happened after the fact, how that deprived her of the statutory right. That's what it keeps on coming.
Counsel,
Sure.
yeah, I think that's interesting. We've never adopted in Pennsylvania an independent tort for spoliation. Is that, by going through the Althouse analysis, is that really what you're asking us to do here, to adopt spoliation as an independent tort? I'm not sure if I know the answer to that.
In terms of spoliation of evidence, I didn't think about it in those terms because of the fact that they didn't necessarily spoil any evidence, destroy any evidence. There was nothing intentional, or it doesn't seem there's anything intentional. But by failing to gather all the information, even if the person they spoke to, the dog owner, said, "I'm not telling you who I am, I'm out of here," still follow to the car, take the license plate, call the Ohio Township Police. Because unless I'm mistaken, I think there is a regulation, a health department regulation, where whenever a dog bite occurs, it has to be reported to the local authorities so that the animal could be checked out if the animal carries any type of disease.
Did cite, in its brief, Home Depot did cite cases indicating that the employer has no affirmative duty to assist the employee's third-party tort claim. Do you take issue with those authorities?
In that particular case, it's an apposite, and I would take issue with it because in that particular case, the plaintiff knew who the defendant was, knew what the damages were able to sue the defendant. That particular case, it seems that there was some foot dragging on the part of the employer. They weren't doing everything they could to provide certain information that was necessary. Well, in that scenario, all the plaintiff needs to do, if the employer's not helping her, is subpoena records, subpoena documents, hold a deposition. Lindsay Franczyk's totally deprived of all that. She just doesn't know who the person is because they refuse to get the information or take appropriate measures to get the information. So I do take issue, just to answer your question, I do take issue with those authorities because they are factually inapposite.
One more brief follow-up.
Sure.
I'll let you go. Assume that you prevail. I'm trying to think further down the chessboard here. It'd be like a trial within a trial, I suppose, because you'd be trying to get a jury to put a number on what you would putatively, ostensibly, supposedly have been able to collect, or have in fact would have collected, in the tort claim against this alleged dog bite owner. Did I confuse?
Yeah, correct,
So
yes.
if you could walk us through how you think, because if we greenlight this for you, then there's a category of such cases available, hypothetically, right?
Yes.
And I'm interested in knowing how those cases get tried and how the damages get put in.
Well, certainly, she's already limited under the statute. I mean, if we go strictly by the workers' comp statute when it comes to the wages and the medical expenses. So she's limited from what she can get out of Home Depot. So if we get to the actual defendant, if we get to Home Depot and we get to this negligence, and to clarify what I said, if we go by 481A, just because of the injury alone, just because she was bit, she's limited in what she could get. Because she was deprived of 481B, speaking to your question, you would have obviously non-economic damages. You would have pain and suffering, which, bless you, which could not be quantified. And you'd have punitive damages, and I think where that would turn is exactly how egregious was the conduct of the employers.
I
That
thought
came
you
up.
said it wasn't intentional.
Pardon?
I thought you said their conduct was not intentional.
So far as the record's been developed, it doesn't appear to be intentional.
So where are you going with this punitive damage?
Well, punitive damages are recognizable, they're cognizable in a negligence claim
Against a third party.
against the third party.
But Home Depot in this scenario, what I was getting at is, maybe I'm getting this wrong. My understanding would be if you could go forward on this, you'd want to be going to a jury with Home Depot standing in the shoes of this dog owner, and so you'd then be trying a case against the homeowner against the dog owner with Home Depot standing in for the dog owner, and then you'd be putting in, I guess, all these alleged damages against Home Depot, right?
Yes.
For having thwarted your investigation.
Correct.
And then presumably also a claim for legal fees, right? I mean, what's the proof on this?
I don't think, under the American rule, there's no statutory support for a claim for legal fees.
Well, you'll get your percentage.
Pardon?
You'll get your
Oh,
percentage.
yeah, we get our percentage, but.
To put a finer point on Justice Wax's question, how do you get to present evidence on damages without establishing in a trial against Home Depot and these two employees that the dog owner, assuming there was a dog owner, was negligent?
But how do I get to a trial on damage, assuming that the dog owner was negligent?
How do you get to present the evidence of what you hypothetically could have or should have been able to recover, but for the alleged impeding, without also having to prove the negligence of the dog owner
That's
that we
correct.
don't know? How do you do that?
Well, I mean, it's, Justice Brobson, respectfully, it's not accurate to say we don't know because it's been alleged, there were multiple other employees who were present at the time who saw the dog owner. In Thomas Mason's deposition testimony, he references a employee by the name of Frank Lebo, who the other manager refused to speak to. Frank Lebo supposedly witnessed it. So in that scenario, it would come down to Ms. Franczyk testifying, they brought the dog in. The dog was not muzzled. It was a big dog. It looked like a Rottweiler, whatever the situation was. The owner was not properly containing the dog.
What does that mean?
What that means is there was a greater risk, depending on the breed and depending on whether the dog was muzzled, whether the dog was, on a leash, how long the leash was. The way the owner was handling the dog would be relevant to how you prove damages against the dog owner.
Okay, damages. I'm talking about the cause of action. Don't you have to, in terms of a tort for a dog, have to prove that the owner had reason to believe that the dog posed a risk or a danger, maybe had a predilection for being aggressive or something like that, such that they had a duty to, as you said, restrain the dog or perhaps not take the dog in there? Don't you have to prove that? And it seems to be a weird time to be proving it when you're suing Home Depot.
Well, part of the reason you're suing Home Depot is because you don't have the ability to prove that. But going deep into your analysis, which is an interesting question, first off, you have a posted store policy. No animals are allowed in with the exception of the service animals.
Dogs. So that was apparently not enforced.
That was not enforced.
That's a workers' comp claim.
No, wait, no. It's not a workers' comp claim. It's a matter of if the customer sees this sign and brings a dog in anyway, wouldn't that be breach of the standard of care? You're walking into a store, you're an invitee, and you're disregarding their policy immediately.
Well, I think, again, that would be an interesting question if you had the dog owner and you could ascertain that.
Yes.
Well, that's the third-party claim.
Yeah.
Correct.
It's,
Yeah. I mean, and we don't, and the reason we're here, Justice Brobson, is because we don't have the dog owner.
And I do want to just ask one follow-up question.
Sure.
Though. Where is the definite injury? Where in the definition of injury in the workers' comp law does it say it has to be a physical? It only applies to physical injuries.
That's I don't have the statute with me, but I mean, on the best of my recollection and knowledge, when they define an injury, it is defined as a physical injury.
You're saying the statute defines it exclusively relating to physical injuries?
I believe so.
Okay.
I believe so. I mean, and again, too, when it comes to statutory construction, we look at the plain meaning of the statute. We go above and beyond. I mean, to say, if one wanted to make a general broad-based statement, oh yes, Lindsay Franczyk was injured, because Philip Rogers and Thomas Mason didn't do what they were supposed to. But her injury is deprivation of a right. Her injury is not the actual physical injury.
Well, I'm glad you said that, because that's what I'm sort of what I'm trying to get at. If you get to go to trial on this, then am I correct that what you seek to put in front of that jury is both? It's both the thwarting of the alleged thwarting of the investigation, so to speak, but it also has to be the underlying bite, right? Because otherwise, otherwise, who's Home Depot standing in there for?
That's correct, and I think we were hitting on that point a little earlier. So, yeah, you get into, maybe it's a scenario where a jury would say no punitive damages are due as a result of the dog owner's conduct, but because of Home Depot's conduct. I think Chief Justice Todd, early in the argument, mentioned the hypothetical scenario where it would be different if the dog owner just took off. What would justify punitive damages in a situation like this? If the dog owner takes off, Ms. Franczyk went to talk to management, the dog owner took off, they had no way of interacting whatsoever, that certainly would not be punitive damages. But by actually speaking to the person she identified and not undertaking any effort to ascertain that person's identity, that could rise to the level of egregious. I mean, a jury may look at that and say, well, that's pretty egregious because,
The problem is, though, if we recognize this exception, putting aside whether the cause of action actually exists, I don't think Pennsylvania law has ever recognized this cause of action, but let's assume, putting aside that question, then in every scenario where there was a third-party tortfeasor that fled or didn't flee, the facts don't matter. We would have carved out this exception, and you would have a civil action in every case to sort of bootstrap onto the workers' comp and really put the burden on the defendant. I'm not going to say Home Depot. I'm going to say the mom and pop grocery store at the corner. If we open, I told him not to go down the road of woe, but if we open that, that's what you're essentially creating this opportunity for. Is someone flees, we see this opportunity to bring a common pleas action along with the workers' comp action, and now you're tied up in litigation and expense over whether, well, did somebody let them flee? Did they not do enough to stop them from fleeing? Right. That's the problem I have with this.
And since we're talking about tort factory here, another product of this tort factory would be the wrongful imprisonment suits against Home Depot or Justice Brobson's mom and pop store, let alone threat of violence, right? When these stores try to detain these people under the fear that the injured employee is going to say, hey, you let this tortfeasor get away and now you've thwarted my ability to bring a third-party suit. So is the message we'd be sending, hey, physically grab these people and don't let them leave the store?
No, that's not the message at all, because, and again, we're looking at a case-by-case situation.
Respectfully, I disagree.
Okay,
I disagree because the only way you get to the case-by-case situation is litigating it in common pleas court.
Well, you have to litigate it, and so some of these cases may go on judgment of pleading, whatever the situation might be.
But once you open the door to the courts of common pleas on these types of cases, it increases the cost of litigation, it increases the potential liability of these employers, and cuts against the grand bargain.
Cuts against, I'm sorry?
The grand bargain, what the workers' compensation law is referred to in Pennsylvania, the grand bargain.
Well, Justice Brobson, the other 50% of that grand bargain is 481B.
481B preserves a common law remedy and provides for an absolute right of subrogation. It doesn't create a remedy. It preserves it and creates a right of subrogation.
Right, it preserves and creates a right, but when the party benefited by 481A deprives the beneficiary of 481B of that right, how much is that right worth?
And we have to allow plaintiffs to litigate in common pleas court whether there was such a deprivation.
That's correct. And
I think you're going to see a lot of those types of suits if we recognize this.
But again, it's something that consider. I mean, in this case, look at if we're going to look at it from, if we're going to get beyond the facts, Justice Brobson, we're going to look at public policy, we're going to look at social justice. This is uncontradicted. Documents were exchanged. She had, because of that attack, she needed ulnar nerve decompression. She had to leave nursing school.
I really don't want to go there. I respect that, but I don't decide public policy.
No, I understand.
For me, this is a statutory construction case.
Okay, and I see where you're coming from, and I respect that. I disagree that it's a statutory construction case because I lean more toward Dittman and the fact that, again, obviously with this court's ruling in Dittman, there's a certain standard, a certain duty that employers have to employees to safeguard their rights. So the question is, where does it begin and where does it end? Some might look at this as a step too far, but how do you escape that reality that, okay, the General Assembly has benefited, has protected employers with the workers' compensation statute and preserved, as you've indicated, Justice Brogson, a pre-existing right. They've preserved that, but what happens when it's gone? What happens when the employer does something that totally deprives the employee of that? I mean, there's significant damage to that employee by not knowing the identity of third-party tortfeasor, and it's not a matter of the third-party tortfeasor running out of the building. It's a matter of the employers telling her, you stand here, you don't go, doing what she was taught during the training. She was trained to do that. You go to your superiors, they tell you what to do, you follow their orders. You stand here, we're gonna go talk to them. Oh, it wasn't me, says the dog owner. I asked Philip Rogers during an investigation, I said, was that good enough, during the deposition, was that good enough for you? His response to me was, well, I'm not a police officer. So speaking to your point, Justice Weck, no, you don't have to physically detain people. I don't think anybody would expect that. But if they don't give the identity, and they're parked on a public street, you could take down their license plate, turn it over to the police. Store like Home Depot, if they used a credit card, you could find out who it was from what they purchased, find out their name. They're a regular customer, you could ask other employees because people tend to frequent stores, the same stores.
That's interesting. In that sort of scenario, would an avenue for you be to sue a fictional named defendant and then seek compulsory discovery from Home Depot for its cameras and for any of its premises data that might lead you and your private investigator to learn who this dog owner is?
Yeah, that's an incredibly interesting question because during the course of discovery in this case, I asked for that information. I still haven't received it. And I've received different responses in terms of how long we keep it, whether we have it. No, you can't talk to us. You have to talk to the manager or the regional manager. And one would think, because that was one of the first lines is going through discovery. Look, if there's security footage and it shows who this person is, and maybe other employees can identify this person, then we might not even have to go down this road.
Well, that would be your obligation, would it not? I mean, generally speaking, it's the plaintiff who has the obligation to identify who the defendant is. You're in an unusual situation here because of what transpired beforehand, but I'm just a little bit confused about this line of questioning about this opening of Pandora's box, et cetera, et cetera. I mean, to me, this would be an extremely unusual situation because pursuant to the Workers' Compensation Act and its various permutations, an employer would want to know the name of the third-party tortfeasor because they have subrogation rights.
Yes.
So, I mean, this notion that there's some Pandora's box being opened here just doesn't make any logical sense. I mean, take, for example, the lawsuit that you would try against Home Depot, seeking damages that otherwise would have been recovered from the dog owner. Home Depot would have subrogation rights against whatever they paid out in workers' compensation benefits. You can't have part and parcel. So anything that you would recover from Home Depot standing in the shoes of the dog owner for damages, Home Depot would be subrogated against anything they paid out in workers' compensation benefits, correct?
Correct.
So you'd essentially have a claim for pain, suffering, and inconvenience.
Well, pain and for lost future wages.
To the extent that.
Because of the fact she had to give up nursing school. But if Justice Donahue, if I'm understanding you correctly, the Pandora's box to which you refer is this would lead to all kinds of litigation, and this would lead to all kinds of liability. This is a very specific scenario. There was one case cited by the appellants that there was some fraud or negligence involved in the investigation of the workers' compensation claim. They cite that case in their brief. But in that case as well, they knew who the defendant was. The plaintiff knew who the defendant was. This is where you do not know. And the employer became involved. It's almost a difference between malfeasance and nonfeasance. I mean, if you're talking about a small mom and pop and you have an 82-year-old proprietor and this happened and the guy, I mean, that's a different scenario than a major corporation with 2 trained managers.
Well, I don't see how it's legally different, but here the dog owner's in the wind, ostensibly, right? So the subrogation claim is it's a chimera, right? I mean, it's not happening.
Well, sure it is. I mean,
how is that happening?
Legally, it would happen because in the lawsuit that he's trying, he's still under the confines of the Workers' Compensation Act. Any damages would be subject to subrogation. So to the extent that you made a claim for lost wages, medical expenses, things of that nature, they would not be recoverable, so to speak, against Home Depot because they're the employer.
Well, they would be recoverable against Home Depot if...
The subrogation clause only applies to recoveries from third parties.
Yeah, recoveries from third parties, and the third party's unknown here.
The question is whether you can double, I think rather than subrogation, it's whether you can double.
Well, no, you can't, I mean...
You can't double recover, but there's no subrogation rate of Home
It's on
Depot.
a different track.
Right.
It's the tort claim, it's not the comp.
I mean, it's like case in point, just by way of, quick analogy, a breach of contract, breach of employment contract. I've seen cases where the defendant employer would use the unemployment compensation to reduce the demand and be able to do so effectively. So yes, what was paid already by their carrier could be reduced from the damages at an eventual trial.
That again. So it would have the same effect as the Workers' Compensation Act would intend under those circumstances.
But it would be no double dipping because
All right, I think we've got it. Is there anything you want to say in summary?
The other thing I'd like to say in summary is I think that in this scenario, in this situation, you have a fact-intensive situation where a statutory right was deprived and consequently common law rights were deprived. And the entire body of case law put forward by the appellant, all those cases have one thing in common, and that's the person who was injured knew who injured them. In this case, we don't have that situation because of the conduct of the employers.
Thank you. This would make a great bar exam question, wouldn't it? Thank you both. Very well done.
We would never bring you anything less, Chief Justice.